Welcome, everybody. Welcome back to the Law Self-Defense Show for a new month, April 1st, 2022. This is not an April Fool's joke. I am actually, believe it or not, doing more of the cross-examination of Lauren Kanarek in the attempted murder trial of Michael Barisone in New Jersey. We did about 2 hours of this over yesterday, 2 hours, 2.25 hours of her cross. I'll do a quick summary of that in a moment. We have about another 2.25 hours of this to go. Now, to be clear, the video I'll be sharing with you of her cross today was actually done yesterday. So we're watching a recording of her cross-examination. And so I haven't seen it either. So I'm as naive to what happens as you. I'm not expecting all that much based on what we saw yesterday of our cross-examination of the previous day. I do know that defense counsel finally tries to get to some self-defense related issues in the cross. I didn't see enough to know how effective that was or how far he got. I just was skipping around a bit and saw it mentioned. So hopefully we'll see a bit of that. So far, I haven't seen much of anything in cross that touches upon any of the really relevant issues, at least none of the perfect legal defenses that would seem to be appropriate on the facts of this case, or at least applicable on the facts of this case. But hopefully that will improve. So I think what we'll do is we'll do our quick introduction video now that we've had a chance for people to come in. Hey, I see Will has signed in. Thank you, Will. Much appreciated. Do my quick video, then do a recap of what's been going on so far in terms of the cross, our assessment of it, and so forth. And then we'll jump into, without too much delay, jump into the ongoing cross-examination of Lauren Kanarek. All right, here we go. Hold on one moment, folks. Let's hit it. Okay, so by the way, folks, if that sounded as horrible in terms of audio to you as it did to me, please let me know in the comments. I'm not sure what's going on with those video clips. I may need to recreate those. So where are we? What is this case all about? So Michael Barisone had a horse ranch. I've been calling it a horse farm, but I've been corrected in that horses don't grow from the dirt. So a horse ranch. Sorry, folks, I'm a city boy, born and raised. A horse ranch dedicated to the sport of dressage. Dressage is apparently a certain form of riding a horse. It's an Olympic level sport. Michael Barisone was a successful Olympic competitor in dressage in his earlier years. Now he has this horse ranch in New Jersey where he teaches dressage to, I guess it has to be taught to the horses and to the riders. So he does that. At some point in the past, he had invited this woman, Lauren Kanarek, to reside on the ranch, to be educated in this. She's a, I guess, aspiring Olympic level dressage rider, or she aspires to Olympic level. She seems, to my eye, a bit mature for Olympic level sports, and she was in her 40s at the time all this started. But I'm told that dressage is something people pursue into their 60s. So I guess in that respect, more power to her. In any case, she was invited to live on this horse ranch by Michael Barisone. She brought her boyfriend with her. Her father, apparently a retired lawyer, played some role in making these arrangements. And unfortunately, the relationship between Michael Barisone, the owner of the farm of the ranch where he lived on the property. In fact, he invited them, Lauren Kanarek and the boyfriend, to live in the same building as him, the same structure, just in, I guess, in a separate part of the building, obviously. Invited them to live there. The relationship became extraordinarily toxic, hostile, vicious, malicious between them. I mean, this was a terrible situation. Lauren Kanarek has no qualms about conceding that she posted absolutely horrific things about her host, Michael Barisone, on all over social media. Really vile, despicable things. She clearly hated this guy, and she's not shy about admitting it. Michael Barisone, for his part, appears, to my eye, to have been maybe emotionally fragile from the start. Apparently, he has a history of being abused all the way from childhood. And he was no match for the evil. It appears to be the evil this woman was willing to sling his way. He asked her repeatedly to leave the property, but she refused. And it's extremely difficult to get rid of a tenant in New Jersey if they don't want to go. They can't really be compelled to leave absent an eviction process. And a formal eviction process wasn't begun until pretty close to the date of the actual tragic event. That tragic event being that this woman, Lauren Kanarek, seemed determined to mentally and emotionally break her host, Michael Barisone. And she appears to have been successful in that, because this all culminated in Michael Barisone shooting Lauren Kanarek twice in the chest. She would survive those gunshot wounds, and shooting at her boyfriend. He was not struck. And that resulted in 2 attempted murder charges against him, for which he's being tried now. And of course, this was New Jersey, so there's also a gun charge, because Michael Barisone had not jumped through the many required hoops in New Jersey for possession of the gun he used in this particular shooting. It was apparently loaned to him by someone who had happened to be around, who'd driven up from North Carolina with their pistol and obviously ammo. So the shooting occurred, and now, of course, he's being tried for attempted murder. You have to wonder what the legal defenses might be in this case. And there's really 3 possible legal defenses, 2 of them what we would call perfect defenses, meaning that if they were successful, they would lead to an acquittal. And a third that is an imperfect, imperfect defense. It cannot lead to an acquittal, but it would mitigate a possible conviction here from attempted murder to attempted manslaughter. And that's no joy. I mean, manslaughter, usually an attempt crime is punished to the same degree as the crime. You don't get a break for having failed. So he'd be looking at a manslaughter type conviction, which sounds terrible, or a manslaughter type sentence, which sounds terrible, except when you compare it to murder. So murder can be life in prison without possibility of early release, forever in a cage. Manslaughter might be 10 years or maybe 20 years with the use of the gun, but maybe a possibility of parole in a third of that time. So you might do 3 or 4 years instead of life. So it makes a big difference. It's still, of course, a felony conviction. Yeah, New Jersey does have imperfect self-defense. Someone in the comments says they don't. Just get on Lexis and look at the case law. Easy enough. So I don't know who Brittany B is, but there you go. In fact, New Jersey actually recognizes, their appellate courts recognize the application, the doctrine of imperfect self-defense to attempted murder explicitly. So there you go. I don't know where you looked it up, Brittany, but there. Don't know what to tell you about that. So, except that you're mistaken. So we have 2 perfect defenses, an imperfect defense, and then a wish is basically what the lawyer might be shooting for here, the lawyer for Michael Barisone on the defense. The perfect defenses would be insanity and would be self-defense. So insanity is really a defense. So we have these defenses. We historically, I mean, this is not much done formally anymore, but historically, we distinguished between defenses of excuse and defenses of justification. Defenses of excuse were applied where the outcome of what happened was not socially desirable. Okay, she's going to make. I guess Brittany wants me to look up a statute. Let me finish this introduction, Brittany, and I'll take a look. But keep in mind, Brittany, that there's more than one source of law. Statutes is one source. The appellate courts are another. So, excuse and justification, 2 different. So excuse, a defense of excuse is normally where we don't want to hold the person criminally liable, but we're not saying the outcome was good. And insanity defense is one of those. It's a defense of excuse. And an example might be someone who's insane and believes that they're firing a gun at a Martian or a robot or a werewolf and kills it. But in fact, it's a pediatric oncologist. So that's not a good thing for society. We've lost a pediatric oncologist. But because the person was literally insane, did not know what they were doing was wrong, did not know they were shooting a human being, we're presuming that to be the case for the purposes of this discussion, then we don't hold them criminally liable. Now, they may be institutionalized for the rest of their life. That would be the quote unquote punishment for the protection of society. They're not simply released, but they're not guilty in a criminal sense. And they would presumably be institutionalized until their doctor said they were no longer a threat to others. That's a defense of excuse, the insanity defense. But there's nothing here that suggests that this comes anywhere near that threshold. Michael Barisone clearly knew he was shooting at human beings. He would know that was wrong. That's unlawful, absent some other legal defense. And the other perfect legal defense would be justification of self-defense. But of course, self-defense requires the 5 elements of self-defense: innocence, imminence, proportionality, and in New Jersey, the element of avoidance and reasonableness. And he has to establish those by some prima facie evidence, each and every one of those. Then the state does have to disprove self-defense beyond a reasonable doubt. But the state only has to disprove any one of those elements beyond a reasonable doubt, folks. Not all of them, any one of them. And frankly, there doesn't seem to be much evidence yet on any of them in support of the defense here. By the way, folks, if you're not familiar with those 5 elements, we do have a free infographic, 100% free, that lists those 5 elements: innocence, imminence, proportionality, avoidance, and reasonableness. Provides a brief description of them. Doesn't cost a penny. You can get that at lawselfdefense.com/elements. If you don't know these 5 elements, you don't know self-defense law. You can't possibly know whether a use of force would be lawful or not, because these are the building blocks of any claim of self-defense or defense of others in all 50 states. Now, sometimes not all 5 elements are required. One or more elements could be legally waived. The element of avoidance is commonly waived, for example, in most states. Under most circumstances in an otherwise lawful case of self-defense. But these are the maximum number of elements, and you ought to be prepared to defend each one, because each of these is a target for a prosecutor if you're claiming self-defense. And the prosecution knows he doesn't have to defeat all these elements. If he defeats any one required element, your claim of self-defense disappears, which is a problem, because self-defense is inherently a defense of confession and avoidance. You're confessing to the underlying conduct, and you're attempting to avoid criminal liability for that conduct on the grounds of self-defense. But if the prosecution disproves one of these elements beyond a reasonable doubt, there is no self-defense. And so all that's left is of confession and avoidance is confession. All that's left is, because you're not saying it wasn't me, I have an alibi, I was someplace else. You're saying it was me. I shot that guy, but I did it in self-defense. Well, if self-defense goes away, all that's left is, it was me. I shot that guy. And that's obviously a walk-away conviction for the prosecution. So please, if you do nothing else, download this free PDF, know these 5 elements, because that's the absolute minimum you need to know to understand use of force law. Okay, so back to that. So self-defense would be the other perfect defense if the jury buys it, if they believe the state has failed to disprove beyond a reasonable doubt any one of those 5 elements, then it would be an acquittal. So no criminal liability, 0 criminal liability, a perfect defense. But I don't see much of that yet in evidence. I don't even see the defense pursuing it much. So the primary victim here, remember, there's only 3 people who saw what happened: the shooter, Michael Barisone, this witness on cross-examination, Lauren Kanarek, and her boyfriend. So unless evidence comes from one of them of self-defense, it's possible that Barisone might not meet even the burden of production on self-defense, in which case the jury won't even be instructed on self-defense. Now, courts don't like to do that. If there's any hint of self-defense, they generally give the instruction. But man, if the available evidence is that light on the ground, the chance of being acquitted on self-defense are pretty slim. Fair enough. Someone mentions in the comment, the dog saw it too. There was a dog involved in this final confrontation. I somehow doubt they will be calling the dog to the witness stand. I somehow doubt they'll be calling Michael Barisone to the witness stand, but they may be compelled to do that if they have no other choice. So those are the perfect defenses, the ones that could lead, in theory, to an acquittal. The insanity defense, I don't see much there. Self-defense, I don't see much there. There is a doctrine called imperfect self-defense, and this is where your claim of self-defense is, well, imperfect. So, for example, self-defense requires that element of reasonableness I mentioned has two components, a subjective component and an objective component. The subjective component means you had to have had a subjective, genuine, good faith belief in the need to act in self-defense. If even you didn't think you needed to act in self-defense, it wasn't self-defense. You fail that part of reasonableness. If you fail reasonableness, one of the required elements of self-defense, you fail self-defense. The other component of reasonableness is objective reasonableness. Objective reasonableness applies where holds that that subjective belief is not by itself enough. So however strong your genuine, good faith belief in self-defense is, it's not enough by itself. That subjective belief also has to be objectively reasonable. A hypothetical, reasonable and prudent person has to have believed that, would also have shared that subjective belief. If you have a very strong subjective belief, but it's not objectively reasonable, you still fail the element of reasonableness. You still fail self-defense. To put it another way, a genuine but irrational, unreasonable belief in the need to act in self-defense is not enough. Now, the effect of imperfect self-defense, if that's the only defect in the claim of self-defense, is not an acquittal. It's not zero criminal liability. It's a mitigation of murder to manslaughter, or attempted murder to attempted manslaughter. Now, so that's the imperfect defense that they may be going for here. And the defense may ultimately argue that, look, even if you don't believe the client's insane, even if you don't believe Barisone acted in perfect self-defense, what these people did to him, the way they emotionally and mentally tortured him, broke him. He was not acting rationally. He did genuinely believe he was acting in self-defense, but if you believe that perception was not rational one, at least give him imperfect self-defense. You're not letting him go, but you're not convicting him of murder. It would be mitigated down to manslaughter. So that's the imperfect self-defense. And the fourth thing the defense might be going for is just a wish. Just attempt to make these people, Lauren Kanarek and her boyfriend, look so vile and monstrous and malicious. And by the way, so far they look that way to me. Make them look so terrible that simply out of sympathy for Michael Barisone, if they don't acquit, at least they would come to some kind of mitigated, lesser included offense as a compromise verdict as opposed to murder. So hold them accountable for something, but recognize that he would never have gotten to this point but for their terribly malicious, targeted, apparently intentional destruction of his emotional and mental state. So, but that's not really law, folks. That's almost purely an emotional argument. Now, emotional arguments can work in court. It's not what I would want to put my money on, but if I had nothing else, what do? You advocate for your client as vigorously as you can. All right, so that's kind of where we are now. Lauren Kanarek, we had over 2 hours of her cross so far. We covered that yesterday. That cross was actually delivered the day prior. We're basically running a day behind court here. Yesterday, she did another couple of hours, I think 2.25 hours of cross. Well, that's not quite right. I think it's about another hour of cross, and then there was some redirect by the state. We'll cover all of that today. The next interesting witness after this, which won't be in this show, but we may do it this afternoon in a second show, would be the cross-examination of the boyfriend, who was the other party who was witness to the shooting and the circumstances around the shooting. Also, apparently, a collaborator in this intentional effort to destroy the mental and psychological state of Michael Barisone. And I've heard his testimony is at least entertaining. So I think we'll probably tackle that this afternoon and see where we get. If we don't have something that looks like it's substantively in support of self-defense as a legal defense by the time we're done with the boyfriend, at least a coherent effort by the defense to attempt to pull that out of these witnesses, which we haven't seen so far, in more than 2 hours of cross of Lauren Kanarek, then I don't see how the defense gets evidence of self-defense in without putting Michael Barisone on the stand, at least substantive evidence. And then, of course, you have the problem of you'd have to believe this guy. And by the way, he's apparently stated that he has no recollection of the shooting, that the circumstances were such that basically he blacked out during the critical moments of the shooting. So what kind of testimony would he give on self-defense that would be credible? All right. So with that all in mind, let me pull up. Oh, I have to learn how to do this blogging thing more responsibly. Let me first mention the sponsor of today's content, without which these shows would not be possible. And that is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay its members legal expenses if the member is involved in a use of force event. And those expenses start big and get bigger fast, folks. If all you do is make someone aware that you have a gun in order to protect yourself, to change their behavior, you've arguably put yourself on the hook for a charge of aggravated assault with a firearm, which is good for 10 to 20 years in most jurisdictions. And your lead attorney will be asking for a retainer of $30,000 to $50,000 for pre-trial expenses, folks. That's not even covering the trial. If you've killed someone in self-defense because you were compelled to defend yourself or your family, and you're charged with a killing crime like murder or manslaughter, it's easy to burn through a couple $100,000 before you ever get to trial. So if you don't have that kind of money stuffed in a mattress, just in case you're obliged to defend yourself or your family against deadly force attack, it can be helpful to have a financial partner behind you to make sure you have the resources you need to fight that legal fight the way you'd want it fought, as if the rest of your life depends on it, because it really does. And by the way, folks, CCW Safe brings a lot to the table besides money. Their national trial counsel, their lead lawyer for these purposes, is Don West. He was one of the attorneys for George Zimmerman. He is a world-class criminal defense attorney. You have Don West on your legal team, you are way ahead of where you would be otherwise. They have retired but career homicide investigators that they bring to the scene to act on your behalf. So it's not just the prosecution that has detectives working for them. You have your own detectives working for you, making sure that exculpatory evidence is captured, witnesses are captured, stuff you absolutely need to wage a robust self-defense. CCW Safe brings that kind of team to you in the event you're involved in a use of force event. Now, I've looked at all the companies that provide similar kinds of services, and I can assure you, I can tell you that I found that CCW Safe is by far the best fit for me. I'm personally a member. My wife, Emily, is personally a member. Whether they're the best fit for you is something only you can decide, but I do urge you to at least take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member, you can save 10% off your membership, the first year of your membership, with the discount code LOSD10. That's LOSD for Law of Self-Defense, and the number 10 at that URL, lawofselfdefense.com/CCW Safe. And the last thing I want to mention before we get started is we have a series of webinars coming up, 100% free webinars. They don't cost a penny, folks. We're calling these our Hard to Convict webinars. They'll be an hour to 2 hours in length, and we're going to bust many of the most common misperceptions, myths about self-defense law, the kind of misperceptions that, if believed, are simply putting you on a road directly to conviction and prison. People get in a lot of trouble because they believe these things they've heard on the internet, or from a gun magazine, or from the retired cop down the street, or from the lawyer who did their house closing. And they're simply not an accurate reflection of self-defense law. So if you'd like those myths to be busted for you, a good place to do that is at one of these upcoming lawofselfdefense.com/hard to convict webinars. Again, 100% free. Now, we have 5 of these scheduled, and they are limited each Now they're all the same, so you're not attending 5. Just pick one at that URL. Just pick one, the date that best fits your circumstances. But each one is limited to 100. And folks, so that's five webinars, 100 each, 500 seats, folks. As of last evening, we had almost 200 seats already filled. And I've only been talking about this for 2 days. And these webinars occur over the course of the entire month of April. So again, I just urge you, if you'd like to have a seat at one of these webinars, 100% free. We don't charge a penny for this. Then I would urge you to sign up sooner rather than later before all those seats are gone. And again, you can do that at lawofselfdefense.com/hard to convict. Brittany B., you're a very active commenter in the chat, which is fine. You've made a legal claim in the chat about imperfect self-defense, and perhaps you're right. Perhaps I'm mistaken. That's always possible. Nobody's perfect. And if I'm mistaken, I will thank you for raising my awareness and correcting my misunderstanding. I would caution that if you are not correct in a claim of law made in the comments, today will be your last day on this channel. So I would just make sure, just like I'll make sure, double check my work. All right, folks. Let's see where we are. Okay, so with that out of the way, let's go ahead and start. It's always tricky making sure I'm pulling the right one here. Okay. Steve, I see Steve says, I tried to sign up, but the link, I guess, for the webinar doesn't work for me. I would maybe try a different browser, Steve. We have a couple hundred people signed up, so it's working. Let me take a look right now and just see if it's working for me. Law of self-defense. Hard to convict. It's working for me. So I would maybe try a different browser or a different computer or something. Sorry about that. We're a small law practice. We're not IT experts, but as far as I can tell, it's working. In terms of comments, if we get hundreds of comments, folks, in the chat, there's no way for me to scroll through and pick out questions from there. If you have a question and you would genuinely want me to answer it, that's totally fine. I'm happy to do that, but it needs to be in the form of a super chat. If you're a Law Self-Defense member, this should be streaming on your Law Self-Defense member dashboard. Every question asked there will be answered, guaranteed. There is no super chat either available or required for our Law Self-Defense members. So if you're a member, I would encourage you to post your question there. We'll definitely get to it. If you're not a Law Self-Defense member, if you're on watching this on YouTube, questions would need to be in super chat form to be answered. Finally, when I checked this morning, we were, let me see if I can find it now. We were, darn it, we were 54 people away from having 30,000 subscribers. So any of you who are watching, enjoying this content, if you're not yet a subscriber, if you could pound that subscribe button good and hard, it's free to subscribe, folks. Pound it good and hard. We would, I mean, it doesn't really mean anything substantively, but it would be nice to be able to get past 30,000. So that would be greatly appreciated. 54 more of you, and we've hit 30,000 subscribers. So that would be great. Also, hit that like button. If you make a comment of any kind, like your city and state, that helps fool the algorithm into sharing our content on a broader basis. As you might imagine, YouTube and all the social media platforms are not particularly amenable to the kind of work I do, the kind of content I produce. That's just the way they are. So we sometimes need to trick them. And if we could do that by hitting that thumbs up, putting a comment in, even if it's just your city or state, that would be greatly appreciated. For people saying they can't see the subscriber count on our webpage, I don't know anything about that, folks. I see it on my end, of course, because I'm the ultimate admin. I don't know why it doesn't show for you guys. Maybe there's a setting I would need to click, but sorry, I don't know how to do that. Oh, last thing I should mention. So next Friday, for those of you who've been following for a while, you would have seen our coverage of the Theodore Edgecombe trial. This was the bicyclist who shot the immigration lawyer, I believe in Minneapolis, I believe it was. So we covered that trial in great detail. I did that over with Nick Requeda over at Requeda Law. Next Friday, a week from today, April 8th, is the sentencing of Theodore Edgecombe by Judge Borkowski. Judge Borkowski is very entertaining. I expect he will be very entertaining at the sentencing. So I'll be over at Requeda Law with Nick to cover the sentencing of Theodore Edgecombe next Friday, April 8th. So you may want to put that in your calendar. I think that's going to be a great deal of fun. All right, folks, with that out of the way, let's go ahead and start. If I can pull up the right window. See if I have the right one. I don't think it's that one or that one or that one. Dear Lord. It should be this one. All right, so the judge is standing there. Now you can see that the judge is standing there, and he will, the jury, I believe he's standing because the jury is being seated, and then the defense will begin with their continuation of their cross-examination of Lauren Kanarek. Now, keep in mind what we're looking for here. We're not really looking for answers, evidence, testimony, or at least questions targeted at insanity defense, because that wouldn't come from here. Insanity defense will come from the psychiatrists and psychologists that the defense plans to call when they present their case in chief. That's how that will work. So we're really looking for testimony evidence that would be consistent with the perfect legal defense of self-defense on the one hand, or the imperfect defense of, imperfect self-defense. So looking to mitigate murder to manslaughter. Again, imperfect self-defense does not get Barisone acquitted. It just means a manslaughter conviction and sentence instead of a murder conviction and sentence. So I expect we may see, because the latter, the imperfect self-defense, really just goes to how mean these people were to Michael Barisone. I think we'll hear plenty of that. Certainly they were mean on social media, so it's all in the record. The defense has it. They're trying to read it themselves. The defense is trying to read those social media posts into testimony themselves, which they're not allowed to do. The lawyer is not allowed to testify on behalf of his client. So they keep getting chastised by the judge. But nevertheless, I expect we'll see some of that. I'm more interested if we see, if and when we see anything that's really directly on point for self-defense, meaning directly on point, relevant to one of those 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. I don't mean to suggest that this witness, Lauren Kanarek, who was shot by Barisone, would agree with self-defense, but at the very least, I expect the defense counsel to ask questions that would be on point for those 5 elements of a claim of self-defense. So we'll see what happens there. There was one more point. Oh, yes. So I'm seeing a lot on social media related to this case about how the judge is being so mean to the defense and is clearly biased and blah, 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 blah. Folks, the defense is really acting poorly here. I mean, this defense lawyer, frankly, often seems like he doesn't really know what he's doing. Like, he doesn't know what the rules of evidence are. He doesn't know how to conduct cross-examination or what the boundaries of cross are. He doesn't know how to conduct cross-examination in a proficient way to effectively advance his client's case. It's kind of a hot mess. And the judge has an obligation to his own court and to the jury to ensure that what testimony is being provided and questions are being asked of witnesses are coherent. So this defense attorney has a propensity to ask very ambiguous, compound questions. Lots of pronouns, lots of vague references to this happened or that happened, to the point where we don't know what he's talking about. And then there are compound questions. So because it's a compound question, isn't it true that you ate a sandwich and drank a Coke? Well, maybe half of that's true and half of it's not. How is a witness supposed to answer? Plus, it opens the door to the witness to kind of deceive by saying, well, I did have a sandwich, so I can answer yes to that, even though I didn't have a soda. So they answer yes, and they're not actually lying under oath. They answered part of the question, honestly. They just didn't address the other part of the question. It's just a very, very sloppy way to conduct cross. And maybe this is all some kind of charade or act on the part of this defense attorney, along the same lines that maybe his client, Michael Barisone, when you see him in court, he certainly seems to be acting like a crazy person with the the twitching and the crazy facial gestures and rocking in his chair and all that kind of stuff. Maybe that's a charade. Maybe he's trying to look crazy to the jury so they'll have sympathy for him or to go after some kind of insanity defense. I don't know. But judging this defense lawyer on his merits, he's not doing a great job. He's often stepping outside the appropriate boundaries for his questioning on cross of Lauren Kanarek on cross in court. And the judge is holding him accountable for that. You're not allowed to ask questions about things. For example, the judge has already told you that you're not allowed to ask questions about. Not everything is admissible in court. So there's lots of sidebars, lots of corrections, lots of clarifications by the judge. That doesn't mean the judge is biased. That means the judge is doing his job. It may mean that this defense lawyer is doing a lot of coloring outside the lines, and he's not supposed to do that, and he ought to know better. So there we go with that. So let's see. First, let me pull up my little super chat window so I can answer those. In fact, I'll take a look now and see if any new ones have come in since we started. Yeah, not yet today. So again, if you're watching this on YouTube and you'd like your questions answered, they need to be in super chat forum if you're on YouTube. Okay, folks. So let's go ahead and get this party started. Oh, for those of you who are new, sorry, last thing before we dive into this. For those of you who are new to watching this trial, when you hear the incessant paper rustling and pen clicking and breathing, that's not me. That's this judge. He's relentless. I don't know who he's writing an angry letter to with all his scribbling and paper moving and pen clicking. He's really pissed at somebody, apparently. And he does it within, it seems, half an inch of his microphone. So we're going to get a lot of that. There's nothing I can do about it. Don't blame me.
Morning, ladies and gentlemen. We're ready to proceed. Please be seated. Officer, can you ask Ms. Kanarek to come in and resume the stand, please? Sure. Thank you. Morning, ma'am. Because we had a break, we're going to swear you today. So if you can place your left hand on the Bible, please. Raise your right hand. My clerk will administer the oath again.
Do you swear in the presence of Almighty God that the testimony you give to this court regarding this matter shall be the truth, the whole truth, and nothing but the truth?
So strictly speaking, she doesn't have to be resworn. I mean, it's very common for courts to say, you're just inform them you're still under oath, and they acknowledge that, and you don't have to go through this. The whole oath thing, the reason they formalize it in this way is to create a kind of stark line, a red line. Before you cross that line, you can lie about stuff because for any reason, you don't want to hurt someone's feelings, or it would be embarrassing to tell the truth, or whatever. I mean, people do that all the time in the normal course of this day. On the other side of that line, if you lie, it's a crime. It's perjury. So we go through this formal swearing in process. I mean, in theory, you could just put a stamp on the back of someone's hand, right? But we go through this to reinforce to the person, you've now stepped over the line. So this judge just likes to do this, swear them in again the next day, rather than simply informally inform them that they're still under oath. Go through the formal process again, just to reaffirm to them that you have now stepped over this line. Lying is punishable as a crime now. I mean, I have to be honest, the number of times you see people punished for perjury is pretty few and far between, and people lie on the witness stand all the time. But where let's say it's aspirational.
I do.
Please state your name and spell your last name for the record.
Lauren Kanarek, last name Kanarek. N as in Nancy, A-R-E-K.
Thank you.
All right. May I have a seat, ma'am?
Thank you,
All
sir.
right, very good. Counsel?
Thank you, Judge. Good morning, Ms. Kanarek.
Good morning, Ms. Lucas.
Well,
Ms. Kanarek,
Yes, sir.
did you ever threaten Mary Haskins?
No,
Did you ever threaten Michael Barisone?
no,
so not quite right, I would say there. She certainly threatened them with non-physical harm. I mean, she threatened to destroy his reputation and so forth. But of course, none of that would be relevant to a self-defense justification. There, the question would have to be, did you threaten some kind of physical harm? She did use a lot of metaphorical language, like she's going to war with them. But folks, even if there were prior threats, even if she had, texted or whatever, verbally said at some time prior to the actual shooting, I'm going to kill you. Those kind of prior threats are important if there was some actual threatening overt act in the moment. But if there was never an actual overt physical act, an attempt to commit the physical harm in the moment, then the prior threats don't mean anything. All the prior threats do is add credibility to the reasonable inference that a threat is actually happening. But there has to be some nugget, some core of threat actually happening. If that's not there, if in the moment she was shot, she was not physically threatening Michael Barisone imminently, unlawfully, then whatever she said prior to that event simply doesn't matter. It doesn't have a slot to fit into.
Do you consider some of the posts you put on social media threats?
I think some could perceive that way, yeah.
So are you saying now that you did threaten them?
No, that's not what I'm saying. I said I did not threaten Michael Barisone or Mary Haskins. You're asking, I think, could you repeat that second
Okay,
question again?
Let me rephrase it. Do you consider the social media posts that you were posting threatening to both Barisone and Mary Haskins?
I consider them, they could be perceived as threatening.
And did there come a time when you knew that Michael Barisone was scared?
No,
Was it your intention to scare Michael Barisone?
maybe at a point.
What point was that?
I don't recall, after being bullied and tortured for weeks and days.
So this is another issue. So the lawyer, it's cross-examination. So in theory, all the answers should be, you can ask leading questions in cross-examination. And in theory, all the answers should be yes and no answers. They should only be narrative type answers if that's what the defense lawyer wants, because it's helpful for his case. Here, he continuously allows this woman to answer his question and then expound on how she was the actual victim in this case, which may be true. None of us knows what really happened in any absolute sense, but it's not helpful to his client. That's stuff that should come out on direct by the prosecution. But he keeps letting her run off like this. He should be asking the judge every single time. First of all, he should be interrupting her the moment she's finished giving the answer he wants. Stop right there. He can do that. And then if she insists, have the judge order her to simply answer his questions and not expound. I mean, the fact that he's not doing that is just bad lawyering.
for these. No. 100C10 and 200. Now, Ms. Kanarek, I'm going to show you Exhibit 200C-32 and direct your attention to item number 2090. May I question?
Yes.
Can you take a look at number item 2090? They're listed on the left by numbers.
Yes, I see. Is a phone call?
Text message from your phone.
Of this phone outgoing? Okay, it's hard to read this map, I guess, a little bit. Yes, I see.
Okay, and does that refresh your recollection as to whether or not on July 25th, 2019, that you, your boyfriend, and your father were aware that Michael Barisone was scared?
I'm sorry, could you just give me 1 second?
This is another thing she does. She keeps having to like find stuff, refer to page numbers, and which is fine. And in fact, and partly the lawyer should be providing her with sufficient detail that this isn't necessary. But she's doing this, I believe, deliberately to diffuse the momentum from the cross-examination.
Sorry, I was just
All
reading
these
her
little boring
context here.
pauses are just distracting to the jury.
Irrespective of the context, isn't it a fact that on that date, July 25th, 2019, that you, your boyfriend, and your dad were aware of the fact that Michael Barisone was scared?
It seems in this text message, because it says Michael is scared. So
Who wrote that text message?
I believe I wrote it.
When you say, I believe
Yes,
I wrote it,
yes.
is there any question in your mind that the records of your cell phone indicate exactly what you wrote on that day?
No, I was just confused because I wasn't sure if this number was me sending the text or the other person sending the text that we were talking in conversation.
Okay, so irrespective of
Yes.
who said it, all three of you knew that Michael Barisone was scared on that day,
I
correct?
wrote the words, yes, Michael is scared, correct.
Now, on August 5th, 2 days before the shooting, were you also aware that Michael Barisone was scared?
Possibly, we thought, perceived that, it's possible.
I show you exhibit D100C10. May I approach that?
Yes.
Do you need this one back?
I'm going to show you this exhibit.
Sure.
And refer you to item number 910 from your phone and ask you to read that to yourself there.
Yeah, I'm sorry, can we? What date was this? Sorry.
August 5th, 2 days before the shooting.
That's what I thought, okay, yes. Should I read what I wrote?
No, asking you, were you aware that Michael Barisone was scared?
It seems that it was perceived that way, although, again, given the context, guess, I'll just say, I'll leave it at yes, if you proceed that way.
Okay. When you say perceived, is there any doubt in your mind that on the day reflected on this document, you indicated that you were aware that Michael Barisone was scared?
Yes. In this message, it seems to say can I read this just so, will that be okay?
No, I'm asking you a specific question, if I may.
Sure.
Okay, was Michael Barisone scared 2
Okay,
days before the
yes.
shooting?
Hold on, that's not the question.
All right, I'll rephrase
No,
it.
it's what she said, her perception. She can't testify about the defendant's state of mind, only her perceptions. Rephrase your.
Again, this is a
It's
basic
withdrawn.
rule of evidence. She's not mind reading
Yes.
Barisone's
Your
mind. She doesn't
perception
know what he was
Of
thinking. It's
Michael
ridiculous for the
Barisone
lawyer to
2
ask
days
this.
before the shooting.
If they want to get
That he was
Barisone's state of mind
scared,
into evidence,
correct?
they have to put him on the witness stand and
Sure,
ask
yes.
him.
On the day before the shooting, was it your perception that Michael Barisone was deathly afraid of your father?
I'm sorry, can you repeat the question again?
On August 6th,
Yes.
was it your perception, based on your observations of Michael Barisone, that he was deathly afraid of your father?
I would not say that he was deathly afraid, but I do think he was afraid of my father. So if it's written somewhere, it's an exaggeration.
If I can approach, I show you Exhibit 200C-47 and ask you to look at item number 512.
Yes, sir. Yes, that's exactly what I thought I probably wrote.
Was your perception the day before the shooting of Michael Barisone that he was deathly afraid of your father?
Was it my perception?
Yes.
It was my perception that Michael was afraid of my father. Again, I don't know if this is another example. Can I read, please?
No, ma'am, just answer the questions that's asked. If there's any follow-up needed, the state can follow up with questions. So
Okay.
just answer the counsel's
Finally.
questions, okay?
Yes.
Thank
it
you.
was my
She tried to get,
perception.
I mean, the judge is having to
time
jump in
he
and
was
do this. The
afraid of
defense
my
counsel didn't even
When you
ask
say
for that
afraid-
correction.
Will you agree with me that there are varying degrees of fear, correct?
Correct.
And can you tell the jury how you described your perception of Michael Barisone's fear of your father?
It was described the way that it was just read.
Can
He
you,
was deathly afraid. That's what was written.
now, yesterday, the prosecutor introduced a photograph of your dog. Do you recall that?
I do.
And it was a picture taken probably many feet away with your dog just sitting there, correct?
Correct.
Oh, these are ours. Did you make us some?
Kristen,
Let me see the picture.
Ms. Kanarek, I show you Defense Exhibit 800D1
Okay.
and ask you if this is another picture of your dog.
Yes, it is.
How about 800D2.
Oh, she's yawning? Yes, that is also my dog.
You described that as a
Where she's
yawn
yawning. So this dog
in that photograph
purportedly
that I'm referring
attacked
to.
Michael Barisone. He had dog bite injuries.
800D2.
Of course, the key issue is
That
whether or
is
not the
yawn.
dog attacked
That's exactly what
prior
that is.
to his shooting of this woman.
And that's something that
in which
you
case
posted, correct?
the dog
Yes, I
might
posted this.
arguably have been a weapon
What type
being
of
used by
dog
the
is
woman.
that?
You sick a dog on someone, that's you
a
attacking
dachshund,
that
which
other
is like the
person,
weenie
not
dog
your
kind of
dog.
thing.
Your dog can't be held criminally
dachshund
liable.
and,
You're using the dog as a
mini
weapon.
Rottweiler.
So if
gets
she
me a
used the
mutt.
dog as a weapon against Michael Barisone, then
those are the things that the
arguably
ASPCA
might have been defending
said that
himself
she was
against
when
the
we
dog's
rescued her.
attack. On the other hand,
Did you
perhaps the
ever
dog
put on
attacked him
social media
because
that she was
after
a
he shot the woman. That's the
Doberman
key issue.
mix?
Maybe somebody might have asked us and we said, yes, possible.
Did you describe her as a guard dog?
Yes,
The nighttime army?
I'm sorry.
Mr. Belinkus is.
That's not
Can I
even
see
a
you at the
question.
bench,
The
please?
nighttime army. What is that? So the judge has to keep calling this defense counsel the sidebar, basically to ask, "What the f are you doing? Is that a question? Is that not a question? Are you just making statements? How is the witness supposed to respond to your statements?"
Counsel.
Ms. Kanarek,
Yes, sir.
during this incident, that dog was outside at some point, correct?
Correct.
And will you agree with me that he attacked Michael Barisone?
Yes,
He was biting him. His teeth were grabbing his body, correct?
yes, her teeth were nipping at him and biting at him, correct.
Did you see that dog biting at his groin area next to his genitals?
No, I did not see that.
Where did you see this dog biting Michael Barisone?
I mostly saw her biting him and Robert in, I guess, just random places while barking. I was really losing a lot of blood, so it's not clear as to where exactly she was,
So she was losing a lot of blood. So this biting she's describing occurred after the defendant shot her. So arguably her dog was biting the defendant in defense of his owner. Not that Barisone shot this woman because the dog was biting her. The biting she's describing occurred after the shooting, not prior to the shooting.
nipping around. Sorry.
Will you agree with me that when you were talking to the prosecutor about what exactly happened on this day, that you neglected to mention that your dog was biting Michael Barisone?
I don't think I neglect to mention it. It wasn't at the forefront of my mind and I wasn't asked, so I didn't answer.
So you'll agree with me that contained in your detailed statement of the event, which you've reviewed,
Yes,
that nowhere did you mention that your dog attacked Michael Barisone?
I don't know exactly. I'm sorry, could you just repeat that question
Sure.
one more time? It's a little
Sure.
confusing.
have reviewed your transcript of your interview with the prosecutor's office, correct?
I'm not sure if I reviewed the transcript. I watched a video.
And will
So,
you agree with me
yes.
that throughout that entire video,
Mhm.
when you were questioned with regards to the specific instance,
Mhm.
nowhere in that video did you mention that your dog attacked Michael Barisone?
I don't remember. It was right after I got out of the hospital. If it's not in there, it was probably not the first thing on my mind to say about what happened when you got shot by the shooter who shot you. Mentioning a dog barking was probably not the first thing, or not, nipping was probably not the first thing in my mind.
When you say nipping, what do you mean by that?
I mean, nipping, like just like, barking, just nipping at the people that were involved in what was going on at that moment, which was not me at that very moment.
Judge, I'm going to object to this photo being shown to the witness.
You're gonna have her comment on a photo of an injury? And her characterization of it? Not qualified to do that, Mr. Malinkus.
Because of this defense lawyer just doesn't know the rules of evidence, which
So,
is
Ms. Kanarek,
more than a little
based on
weird.
your recollection of the event, it's your testimony that your observations of your dog were that he was just nipping at Michael Barisone.
Yes.
Was he nipping hard enough to break the skin?
How would he know how hard the nips? How would
I
she
have
know
no
how hard the
idea.
nips were?
They're all wearing clothing, so I have no idea.
Now, on the 6th, did that dog attack Dr. Cox?
I believe,
Again, didn't I rule on this already, Mr. Malinkus?
So, mic off. Judges chastising the defense. So, as long as we have a pause here in the action. Let's see. Did everything freeze? No. Okay. As long as we have a pause here, I'm going to post up a comment here with 3 New Jersey appellate court decisions. This is in response to the suggestion earlier today by, I don't remember the name now. Let me scroll up to the top. Brittany B. Brittany B. had stated that New Jersey does not recognize the doctrine of imperfect self-defense. And she cited me to New Jersey self-defense statute 2C:3-4. So is Brittany's statement correct that New Jersey does not recognize the doctrine of imperfect self-defense? And I'm afraid, Brittany, you are incorrect. So I will post up just three of perhaps over about 100 New Jersey appellate courts that discuss the doctrine of imperfect self-defense, none of which say it's not recognized under New Jersey law. And I'll discuss the merits of those 3 here. Now, well, actually, I can't, looks like I can't post all 3 at the same time. So I'll post them, I'll have to post them individually or in 2 chunks. There's one comment. There's the next comment. All right, Brittany. So Brittany's fatal mistake is her, frankly, her failure to understand how the law works. The statute she cited in support of her claim that New Jersey doesn't recognize imperfect self-defense never mentions the words imperfect self-defense. It doesn't talk about them. That doesn't mean imperfect self-defense isn't recognized under New Jersey law. It merely means that particular statute doesn't address the doctrine of imperfect self-defense. That's very common. Also, there's more than one source of law. There's statutory law, and then there's case law, appellate court decisions, and they are co-equal. It's not necessary that a statute make law. The law could still very well exist without a statute. A good example is California is a stand your ground state. It does not impose a duty to retreat before you can use force in self-defense. Indeed, it's a very aggressive stand your ground state. California law says that you can, in fact, pursue your aggressor if necessary to ensure your safety from that aggressor. Pursue. That is a very robust stand your ground law. But you know where you find stand your ground, that doctrine in California statute? You don't, because California doesn't have a stand your ground statute. That doctrine of stand your ground, which is in the modern, current, today, California jury instruction on self-defense, so it's what juries are instructed. It is current law. That California law on stand your ground is not found in California statute. There is no California statute on stand your ground. It's found in California case law, appellate court decisions, California Supreme Court decisions dating all the way to the 1800s. Similarly here, there is no New Jersey statute on imperfect self-defense, but the New Jersey appellate courts recognize the doctrine and recognize the appropriateness for jury instructions on imperfect self-defense if the facts support those jury instructions. So I'll share with you just 3 of the nearly 100 New Jersey appellate court decisions that recognize the doctrine of self-defense. The first of these is State v. Bowens. It's from the New Jersey Supreme Court back in 1987. And if you think that's old, I guess 1987 sounds older to some of us than to others of us, but case law lives forever until it's reversed. And I can tell you this has not been reversed, but don't worry, I have more current appellate court decisions on this doctrine. I'm just starting with the New Jersey Supreme Court. So you know that the highest court in New Jersey recognizes this doctrine. State v. Bowens, the court said, the statutory definitions of self-defense in a code like New Jersey's provide no room for the theory advocated by the defendant that an honest or good faith but unreasonable belief that self-defense is necessary merits leniency. So they're saying, yeah, the New Jersey statute for self-defense does not recognize this notion of imperfect self-defense. The code does, however, the court continues, the code does, meaning the statute does, however, permit consideration of a defendant's state of mind. Of course, self-defense involves a defendant's state of mind. That's what the element of reasonableness is all about, the subjective state of mind and the objective state of mind. So the court continues. I guess I should be saying, quote, unquote, end quote. Quote, here we focus on the second factor of self-defense, whether the actor's beliefs are reasonable. Again, this is the New Jersey Supreme Court. In this context, quoting, in this context, imperfect self-defense would mean no more than an honest, subjective belief on the part of the killer that his actions were necessary for his safety, even though an objective appraisal by reasonable people would have revealed not only that the actions were unnecessary, but also that the belief was unreasonable. Close quote. So there's the state of New Jersey Supreme Court recognizing the doctrine of imperfect self-defense. But that was back in 1987. So you may be thinking, well, that's old law. Maybe it doesn't exist anymore. So let's go to 2008, 20 years later, some 21 years later. Right? Yep. And here we have State v. Jackson, that 2008 case from the Superior Court of New Jersey. This is the mid-level appellate courts. State v. Jackson, the court said, quote, where the facts clearly indicate the possibility that the crime was manslaughter based upon imperfect self-defense, we see no reason why the trial judge should not also be obliged, even without any request being made, to so instruct the jury. close quote. So there's a 2008 appellate court case, State v. Jackson out of New Jersey, where the appellate court is recognizing that an instruction on imperfect self-defense is appropriate when supported by the facts. But we're not done yet. Here's a decision from, again, the New Jersey Superior Court, the mid-level appellate court, State v. Guadalupe, from November 2021. So 4 months ago. And it reads, quote, the New Jersey Supreme Court has held that the criminal code does not provide an independent category of justification under the concept of imperfect self-defense. That's what we just talked about. There is no statutory imperfect self-defense. However, such evidence may be relevant to the presence or absence of the essential elements of statutory offense. And objective reasonableness is an element of murder in the sense it's a negative element under self-defense of murder that would mitigate murder to manslaughter. So, Brittany, I'm afraid you're mistaken. If you can find any New Jersey statute or case law that says the state does not recognize imperfect self-defense, when I found nearly 100 where it does recognize imperfect self-defense, feel free to bring it to my attention. I would ask that you do that before the end of today's show as a reason why you should not be blocked from this channel for having falsely stated law to this audience. Thank you. Okay, so let's go on with this. All right, here we go. Blah, blah, blah. We're still on that pause where the judge is presumably castigating the defense once again. Oh, come on. Good heavens. How long is this going to take?
That you
Okay. What you're seeing from the courtroom footage here, folks, was recorded, was yesterday. So we're viewing a recording. I'm live. If you're watching this live on April 1st, 2022, but the court footage is from yesterday.
Objection sustained. Move on, Mr. Blankus.
No, again, imperfect self-defense is not perfect
yesterday you
self-defense. It
talked
doesn't
about
get you to an
a
acquittal. It
plan
mitigates murder to manslaughter.
that you had with regards to Michael Barisone. Was part of your plan to destroy Michael Barisone was to contact DIFIS or DCPP?
This is the judge writing on his pad again.
No, at least, no, actually.
Did you, in fact, contact DIFIS?
I in fact did not contact DIFIS.
So all this kind of stuff, he's asking her, did you contact person X? And she says, no, I didn't contact person X. What was the purpose of that question? You don't ask a question like that unless you have reason to believe and proof, evidence that she did contact person X. So either you're advancing the cross-examination or you're impeaching her. But here he asks her questions where she can just say no, and he's got no place to go from that no. What was the point of that?
On July 10th, 2019, did you search on your phone for the DIFIS hotline?
I don't recall. I don't believe so, but I don't recall.
on July 31st, do you recall searching DIFUS anonymous hotline?
I do not recall, but it's possible.
I'm going to show you what has been marked.
What is he doing?
Defense Exhibit 200D1. And I'm going to refer you to item number 83.
Sure.
I see we still have Bailiff Mike in the background there behind the defense table. You know,
What's that?
Bailiff.
Counsel.
80,
Jersey
83,
Mike.
Judge.
Thank you.
It's July 31st.
This looks like a search or something, not a phone call.
I asked you specifically, did you
Yes.
search for DIFUS's anonymous hotline on that day?
And I didn't recall. Now you've shown me, now I recall.
folks, I have no idea what law and crime might have been saying about the judge.
Did you
I
also
have no knowledge of any of that.
For
I don't see this judge
hotline
doing
on
anything
July
wrong
10th.
at all.
Possibly.
If anything, he's trying to keep in check a defense attorney who appears not to know what he's doing. Now, the defense is not better today.
I'm showing you the same exhibit. I'm referring you to item number 206.
Folks, I would just ask you to compare this kind of cross
If that refreshes
to what we
your
saw in the
recollection,
Curtis Reeves case, defense
to whether or
cross-examination
not
of
you were
state witnesses,
searching
or what we
for
saw
DIFUS's hotline
in the
on that
Rittenhouse
day.
case.
The 10th.
Different.
That's what
same,
effective
different
cross
day.
looks like. This
Different
is
day.
not that.
Yes,
So when you say possibly, you did in fact search for DIFUS's number on those two occasions, correct?
it looks that way, yes.
When you say it looks that way, is there any doubt in your mind, based on those records that I just showed you, that you did in fact do that?
There is doubt
I mean,
in
if
my
they were
mind,
speaking a
but
language I did not
again,
know, if they were
it is
speaking
on my
French here,
record,
I would
so
think that maybe
it was
this lawyer
searched
was actually making a
from my
relevant
phone.
point here.
What is
But
the
he's
doubt
not.
in your mind? Can we talk
His
about
tone
that
of
for a
voice
second?
and his manner
Sure.
suggests he's making a relevant
Where'd you
point.
like
But
me-
what is this
What's
point
the
relevant
doubt?
Let
to?
him ask a question.
What is
Go ahead,
the
ask a
doubt
question.
in your mind after looking at those records that you in
Yeah,
fact
Corey
were
Chirafisi
searching
during the
for
Rittenhouse case was
DIFUS's
excellent
anonymous
at cross.
hotline?
Very, very good. Very targeted, very
doubt in my
directed,
mind
very
is this.
deliberate,
Earlier that year,
contributing to the
Justin
overall
Harding,
narrative of the
Michael's
defense.
assistant trainer, had stolen my phone at a restaurant, and we caught him, we called it, and we found him in his vehicle.
And for people
breaking
asking
into
if
my
this
phone and
defense
going
attorney is
through
a
it,
public
just like a
defender,
month or
I
two
have no
before.
idea. But there's plenty of
So,
awesome public
well,
defenders
yes,
out
it's
there, folks.
possible
The fact that
that I
an
was just
attorney is a
simply
public defender
searching
does not mean they don't know how to
For
do
a
cross.
hotline number, or just making.
In fact, I would
inquiries
suggest that
online.
it's far more
It's
likely
also
that the
possible
typical public
that
defender
Justin
is
Harding,
vastly superior
who does
at cross
possess
than most private practice attorneys. Public
phone
defenders do
technological
nothing
skills
but
that I
argue
do
in
not,
court every day.
after having stolen my phone.
Most
and
private
broken
attorneys
into
can't
it,
say that. None of them
just
can
right
say
before
that.
this, may have been able to do things on my phone that I did not. And so that's the only reason I'm saying this. I don't know whether that's true, could have definitely been me, but there's always a doubt in my mind in regards to things that were done after that phone was stolen.
Yeah, folks, to emphasize that point, there's plenty of private criminal defense
separate
attorneys who may count their actual trials
Seems that way,
in the
yes.
dozens or the scores over a career, and plenty of public defenders who just in the first few years of practice might have been in hundreds of trials. It's just not comparable.
Now, on the 6th,
Mhm.
you're aware of the fact that the townspeople came to this facility, correct?
Correct.
So one of the really vile things this woman did was she called the town authorities, like the zoning board and Department of Health and so forth, to this horse ranch and told them, hey, there's all kinds of violations here. And there were all kinds of violations, I guess. I mean, the town found a bunch. Ironically enough, it was this woman's boyfriend living with her on the farm ranch who was doing that work for the owner. So did he create a bunch of violations? In any case, the essential effect was that the defendant was basically made homeless when a bunch of these structures were prohibited from occupation. And he found himself living on the porch, on a mattress on a porch of one of these buildings. That's where he was sleeping at night. I mean, these are horrible, vile people by all appearances. But none of that justifies shooting this woman twice in the chest.
Can you inform the jury how that came about?
Sure. So at this point, no one is speaking. Michael's girlfriend at the time.
Yeah, these people
and
deliberately,
Michael, but
intentionally
mostly the girlfriend,
conspired to
the
destroy
couple
this defendant's
together
life.
had told the staff members apparently not to respond to any of our messages. If we had a question about feed, don't respond, nothing. We learned that, I think we were doing night check, that there is a dryer, not a washing machine, but a dryer, a clothing dryer, that was plugged in the on position and would not turn off. And as a horse owner, that is your biggest fear, a barn fire. That is all you think about. We texted, or I texted one of Michael's main staff members. This is Cassandra. We overheard you telling Ruth that the dryer is not turning off and she's sleeping. She didn't hear you. And that will definitely cause a fire. Could you please just confirm that you've turned it off or it's unplugged, anything, just so I can go to sleep for the night, basically. She did not answer me. I think I texted her again saying, Cassandra, please, I'm really, really worried about this. The dryer's on, it cannot be in the on position while plugged in, just going in all night long in the stable area where all my horses are. Again, she ignores me. I believe I might have texted Michael also. And if I did, it was certainly ignored. And I think the following day, or maybe the day prior, whenever this incident happened, and there was zero response, nobody was letting us know, just, yes, it's fine, it's off. You're good to go. It was my decision to let the fire marshal know there were fire hazards going on. They were not answering us, and we needed to take it to a different level and bring it to the attention of the fire marshal, because that's how scary it was for us at that time.
Isn't it a fact that part of your plan to destroy Michael Barisone was to get him kicked out of the stable area and make him homeless?
Maybe,
Maybe?
yes, maybe.
See,
So,
I mean, she comes across as completely sociopathic. She doesn't care if she was going to make him homeless or destroy his reputation in the dressage community, which I would imagine is a pretty small community, relatively speaking. She wanted to destroy this man. And by all appearances, she was effective at that. Again, not justification for shooting her twice in the chest. You may wish that we lived in a society where that was permissible in response to this kind of personalized destruction. But it's not.
would you agree with me that it's a little bit more than maybe a washer or a dryer causing an issue than what you just testified to?
No, because we had no idea that would be a result of calling a fire marshal and building inspector. So I would not say it was a plan to get him evicted from, at least not my plan, to get him evicted from the barn. We simply called the fire marshal and building inspector. I have no idea what the building inspector thing was exactly. That wasn't my forte, but the fire marshal part of it was.
I can approach you. I'm going to show you
Sure.
the exhibit 182.
Frankly, folks, I don't really think she's lying because I don't think she needs to lie about any of this because
Yes. I'm sorry.
it doesn't go
This a
to. She's not on trial here.
1.5-page letter
The defendant's on trial. Michael Barisone is on
that
trial,
you wrote
and he has legal defenses he needs
the
to raise against the
building
attempted murder charges against him.
and
And
fire marshal.
none of these questions are really relevant to any of this,
I wrote
unless
my hand.
they're going for this imperfect self-defense
So,
argument.
First of all, there
in
was
any
a
case,
lot
she
more
can't-
than a call,
I mean, she said
correct?
so many horrible things she's had to concede
There's
already.
this
I
blood-
I don't know where lying would get her. Why
I'm not
bother?
even sure if there was a call, actually. But there was, we notified them. I should have used that word.
Okay, so
I
when you,
apologize. They were notified.
Yeah.
you
So
just
I mean,
testified
listen, the
that
shooting
you
can be
called
totally
that
understandable,
was incorrect.
but not legally
I
justifiable. I mean, we had the
I'm not
case
sure if we actually
a month or so
called
ago
or-
where the retired
I should've
MMA
just
fighter shot
notified.
someone who'd purportedly
Call
been
is
molesting
probably
his
the wrong choice of
his
word.
daughter
When
or
you
some
say
young
notified,
female
Did
relation.
you send the
And
town
I mean,
a
who would not
detailed letter
have a human desire
with
to do that?
regards to
But that's not
various-
lawful.
issues at both the house and the stable?
Yes.
Did you inform them that the condition was dangerous and possibly illegal?
Sorry. Could you just repeat the question? I wasn't sure if you said which area.
I don't know what's
referring-
lawful in Russia,
you're
folks.
referring.
I presume
Would
it's
you
whatever
agree with me
justice you
that
can
this
buy.
letter
But I
sets
only
forth
know use of force law for America. That's it.
numerous things that you alleged create a dangerous situation
Yes, that
at
would be,
both the house and the stable area.
that would be a correct
Yeah,
statement, yes.
And part of this has to
So-
do with the
This is how this works. This is supposed to be
That is
a
currently
friendly,
going on,
argumentative
correct?
community,
Correct.
not
And isn't it a fact that your boyfriend
one
was
where
doing
people
a lot of the work?
tell each other that your mother should have aborted
Pretty
you.
much all
So
of it.
there goes
most-
Raven,
yes,
whoever.
correct.
You're blocked.
You basically indicated to them that it's a very dangerous and illegal situation, correct?
I'm just reading back. Yes, that was written. I was just noticing, it was Robert Goodwin that actually wrote it, but that's, I guess, not important. Yes,
When you say Robert Goodwin actually wrote it, doesn't your signature appear on it right below his as a witness to
Yes.
this letter?
yes.
And who drafted this letter, you or Robert?
We drafted it together. It was supposed to be typed, so it wasn't supposed to be written like this, but it was drafted by both of us.
Folks, there's a
Did you
lot
have
of
Robert personally
back and
go
forth in
down
the
to
chat
the town?
between all of you with each other,
I
which is
didn't have-
totally
Talk to these
fine.
people?
I didn't
But
have Robert
if you're
do
using
anything,
pronouns,
simply
first of all, I
wrote a
can't tell
letter
what's supposed to be directed
that
at me or not.
we
When you
both
write you,
composed together
I don't know who you is.
that
But if you
I
do
think
want to
expressed
direct
our
something to my
concerns
attention
over
personally,
several
just
things.
you got to make it a super
And
chat, and I'll be sure to
By
address it.
doing that, you knew that quite possibly Barisone would be kicked out of the stables, correct?
Incorrect. We did not know that was going to be a result of anything. We just wanted them to
Is
check
uncivil law in the
things
chat?
out. And my main concern was, again, the fire hazard, which is the first.
Hey,
one.
Kurt, if you're in the chat, let me know. I'll send you a link to join in if you'd like.
So on the 6th, the day before the shooting, the town people actually came, correct?
I believe so. I believe that was the date, is what I'm saying.
You were on the property that day, correct?
Yes, I just don't remember if it was that day or the day before. But they were there.
And when those people came, did Rob Goodwin show them around and point out the hazardous conditions?
If he did, I wasn't with him, so if he did, I don't know.
I mean, so she was what? She was mean by pointing out purportedly hazardous conditions out of malice? Where does that get us?
After the police, strike that, after the town officials came through both the farmhouse and the stable area,
Yes,
they basically put notices on the door indicating that everyone had to vacate, correct?
of this stable area only?
Stable and the farmhouse where you and Robert were living.
I'm sorry, that seemed like two separate questions. Is there-
Okay, I'll-
Just
Again,
break it
another
down, Mr.
compound
Blanchett,
question.
One at a time.
With regards to the structure that you and Robert Goodwin were living in, did the town place a notice on the building indicating that it was a hazardous condition and that you could not occupy the structure?
Yes,
Okay, I'm going to show you D 822 and ask you if these are the notices that were posted on the farmhouse.
I'm just making sure. Yes, those are notices.
And did you read these notices?
I did,
And it indicates that if you don't leave the premises, it subjects the owner of the building to a $5,000 fine per day, correct?
that's not what I recall reading, no.
Well, what do you recall reading regarding these notices?
I recall reading that in our specific section of the house, there were smoke detectors that were for some reason not working, that I guess the building inspector seemed to think that Mr. Barisone had ripped out the hard wiring for some reason, and we read those, and then they gave us the opportunity to fix them and re-enter the property. That's what I read.
You read that on these?
I mean, I read those violations, yes.
Okay, and those violations say, if you remain on the premises, the owner is subject to a $5,000 fine. Do you recall reading that?
No, I just got to the violation. I don't remember reading the entire thing at all, just violations.
It's your testimony that you had communications with the town, correct?
Correct,
And you remained on the premises with your boyfriend, Robert Goodwin, correct?
correct.
And even though you remained on the premises, you continued to display the notices that were placed on all the doors, correct?
I honestly don't remember that picture. Looks like maybe it was after,
When you say you don't remember,
I don't remember.
you've seen photographs that the prosecutor shown you regarding this incident,
I
correct?
have,
And those photographs include pictures of the door.
Hey,
where the
Shane
bullet
Souza,
hole went
I've
through,
gone ahead.
correct?
I figured it out. I've gone ahead, added you as
If I show you
a
this
mod.
photo again, 822.
I don't
Does
know
that
if you
look
have to
like the
reload the
door
page or what, but
with the
I think I've done what I need to
shattered
on
glass
my
on it?
end.
yes, it does. Yes, it does.
Would you agree with me that if the glass was shattered,
Judge, I'm going to object to this line of
I'll
questioning.
withdraw?
Move on.
Yeah, I mean, her conduct could mitigate especially if it's qualifies as imperfect self-defense. If they're successful, it would mitigate murder to manslaughter. And then when you're sentencing for manslaughter, the fact that he was intentionally targeted for psychiatric destruction by this woman may mitigate, in the judge's view, may mitigate what the sentence should be within the range for manslaughter.
On August 5th,
But
the
that would be up to the
day-
judge.
you sent that letter to the town. Did you receive a letter from Michael Barisone's lawyer basically telling you to get out?
Basically saying that, yes.
And did that make you angry?
Yeah,
Okay. And on the 6th, the day the town came and kicked Michael Barisone out of the stable, were you served with an eviction complaint?
I'm sorry, an eviction
An
permit?
eviction complaint.
We were never served with court eviction papers of any kind, aside from the lawyer.
Are you 100% sure of that answer?
I would say yes. I didn't see anything. Nothing was on our door saying you were being evicted. I was not served with anything. So
But even if she was, what difference does it make? An eviction notice, the tenant has rights too. They have rights to fight that eviction if they think they have grounds to do that. It's not the landlord who just says, hey, here's your eviction notice, get out, and you're automatically obliged to simply vacate the premises. There's a legal process that follows. And it doesn't go to any of the relevant legal elements.
yes, that would be my answer.
Now, on the 6th and the 7th.
She's not married. She has a boyfriend. But some
You were
men
still-
like this kind of woman.
Posting negative things about Michael Barisone, correct?
As we mentioned yesterday, it's reputed that women of the psychiatric state bring certain things to the bedside table.
Now, on the 7th, strike that. Prior to the 7th, on August 4th, were you angry at Michael Barisone?
Yes,
Were you searching for exploding bullets on your phone?
I'm sorry,
Objection.
Let me see that sidebar.
So what difference would it make if she were looking for exploding bullets? First of all, plenty of people in the gun community have looked for weirder things than that on the internet. It doesn't mean they have any malice towards anybody. But even if she was looking for exploding bullets for the purpose of killing Michael Barisone, she never put that into execution. So what difference does it make? It's just an effort to try to make her look bad, like negative character evidence, which would not be admissible if she was on trial, and she's not on trial. She does come across as a psycho to my eye as well, but you're not allowed to shoot people because they're just a psycho, at least not in the absence of them presenting as an imminent deadly force
Now, on
threat.
the 7th, was there an issue with your boyfriend and the blacksmith the morning of the shooting?
so there was an issue with our farrier.
Yeah,
I
she did.
do
She
not
did have a
know
funny expression on her
morning
face when
today.
she took that sip of water. It's like, this doesn't taste like vodka at all.
I'm referring to the
Judge, I have a hearsay objection.
issue.
Well, was she present? Is this something she knows from her own personal observations? You have to establish a foundation, counsel. Otherwise, it's hearsay. Yes, she knows about it, but from what source? If it's from her boyfriend telling her, that's hearsay. If she was present and observed
Look how
it, she'd be
confused
able
this
to
lawyer
testify
appears.
based on her
Like
own
he's learning what
perceptions and
hearsay
recollection.
is right now in real time. Oh, Your Honor, I didn't know
On the
that.
morning of the
Thank you, Your
shooting,
Honor.
were you angry at Michael Barisone?
So that last question's withdrawn, right?
Yes, sir.
All right. Record will reflect that.
On the morning of the shooting, were you angry at Michael Barisone?
Yes.
And did you want that bastard finished?
Yes.
You wanted that bastard finished.
It was asked and answered, Mr. Belankis. One time is enough for the jurors.
I mean, just ask her, isn't it true you're a
No.
horrible witch? And she'll say, yeah. So what?
You were never afraid of Michael Barisone, correct?
I'm sorry, can you repeat that question?
You were never afraid of Michael Barisone, correct?
Not correct.
Do you recall an occasion in July where he came to talk
Just
to
because
you?
he's an older
And there
gentleman,
was an
not unlike
altercation
myself, doesn't
between
mean he's
you
been
and
practicing law for very long, folks. Plenty of people become
Probably
lawyers later,
Few, so
in later years.
yes.
For all we
You
know, he's brand
remember the
spanking
time
new.
he
I don't really know
drove
anything
down
about
in
this
his
lawyer
truck,
except his performance here in his
similar to what he
courtroom,
did on
which is,
this day,
to say it's
come and
unimpressive
talk to
would
you
be an
about
understatement.
something.
Yes.
Do you recall in that instance, getting into a semi-rage and backing him up all the way to his truck, which was parked in front of his porch? Do you recall doing that to him?
No.
Again, this is objectionable.
Do you recall him
This lawyer is
trying to
testifying.
open his door, pleading to leave, but you literally stood in his door so he could not drive away? Do you recall doing that to him on that day?
No, I do not recall doing that to him.
Do you recall when he tried to
No,
open
Vincent
his truck
Gambini
door?
was
that got
excellent.
slammed
Hold on,
shut?
hold on. Let me see that sidebar.
Again, this is not appropriate cross-examination. The judge, frankly, is being kind at this point, asking counsel to come up to the bench so he can chastise this lawyer without the jury overhearing it. I mean, this is ridiculous. And Joseph Gambini was outstanding at cross-examination. Just watch that, trial. He was outstanding. I don't know who the legal advisors were on that movie. Of course, we're talking about My Cousin Vinny. But whoever provided that legal counsel to that scriptwriter, they knew what they were talking about. Folks, this is not that unusual. We're sometimes spoiled by the quality of lawyers we see in some of these trials. Remember, lawyers are on a bell curve, just like just about everything else in the world. And fully half of the lawyers are below average. Some of them are well below average. This is one of the risks of being involved in a use of force event where you may be charged and may be prosecuted, is you might end up with a lawyer like this. And that's not good, folks. You don't want to be there. Your life is in that person's hands. All right. Well, as long as we have a pause, I'm going to mention again our upcoming series of 100% free law of self-defense webinars. Come on. We have a series of 5 of these over the course of the month of April. They don't cost a penny, folks. They are 100% free. We're not charging anything. And in these webinars, they'll be an hour to 2 hours long. I won't really know until we get into one. And partly it depends on how many questions there are. We're going to bust the most common myths around self-defense law. Myths that people believe because they've heard it 1,000 times on the internet or social media or some gun forum or their retired cop neighbor down the street told them, or their concealed carry instructor told them, or the lawyer who did their house closing told them, and they're wrong. These are misconceptions about use of force law, and if you believe them and carry them out in a use of force event, you are likely to go to prison, certainly likely to be charged and incur tens or hundreds of thousands of dollars in legal expenses. We don't want that to happen to you. So we're doing these free webinars. They're all the same, so it's not a series or anything. Don't sign up for more than one. But if you cannot allow yourself to be misled by these common myths of self-defense law, we're going to bust them for you for free at these webinars. They're 100% free. They don't cost a penny, but we are limited to 100 people per webinar. So there's 5. That's 500 people. When I looked last night, we had almost around 200 people already signed up. And I've only been talking about this for 2 days. So if you're interested in attending one of these hard to convict webinars, I would encourage you to point your browser to lawofselfdefense.com/hard to convict sooner rather than later. Folks, there is a minimum level of competence you need to have in use of force law. If you're ever contemplating having the privilege and option to use force in defense of yourself and your family, there is a minimal level of use of force law competence you have to have. I mean, at the very least, you want to know enough to know whether the lawyer you're talking to represent you looks more like this guy or more like a Corey Chirafisi. There's a big difference between those two lawyers. They both passed the bar. They're both admitted to practice. They are not the same attorneys. You want one a lot more than you want the other. So please educate yourself, and you can do it for free at these hard to convict webinars at lawofselfdefense.com/hard to convict. They're free. I can't make it less expensive than free, folks. Okay, I'll pull up the court again. Let's get back to that. Here we are. Here's the horse lady. Right now, defense counsel is getting yelled at again at sidebar by the judge. Frankly, appropriately so. Everybody's coming back. There's the mics.
But the objection's overruled. With the court's direction, Mr. Belenkus, you can continue.
So, so the state's objection was overruled. The court's only doing that because he's corrected the defense counsel. He's told the defense counsel, hey, if you're going to do it, you have to do it this particular way. So the state's objection is no longer relevant. That's why it's overruled. But defense counsel, I assure you, has been chastised. That was not a win for the defense, that little sidebar chat right there.
With regards to this incident referred to on July 12th, 2019, when Michael Barisone came to talk to you, at some point he was trying to run away, correct?
I don't recall.
At some point, he tried to open up his truck door to get away from you, and you slammed it shut and wouldn't allow him to leave, correct?
I don't recall. He came there to confront me in my face, and I really don't recall what happened after that. I was in fear.
You were in fear on this day?
Yes.
Do you recall him pleading with you to leave?
I do not recall that, no.
And you literally standing in his door so he could not drive away.
I don't recall that.
Okay, I'm going to show you D200C35.
Yes. Which number was it?
There's a whole bunch of numbers. Let's go first with 4489, the top.
Okay. So the whole thing?
No, read this one. We'll go one by one. 4489.
So most
It was a
people
text message, correct?
Yes. from
are
your
frankly
phone.
not competent to pick an attorney. They just don't know enough to ask the
Yes, I
right
will.
questions and know what kind of answers to
And
get
does
from a
refresh your
prospective attorney.
recollection on
To
this
them, all
day
attorneys look the same. They all have the little certificate on the wall, the admission to the bar, the
that
law
he
school
came to my
degree.
porch,
And if you know
got in
nothing
my
about a
face
subject and the other
tried
person
to
knows even
berate me,
1%, they seem
but
smarter
all
than
I
you.
did
It's a real
is
problem
make
in the
me
legal
throw
profession.
down my
Unless
phone
you have
and stand in his
someone
face
you already
until my
know, believe to be
semi-rage
a competent
and
attorney that you
backed
could
him
ask
all
for
the
a
way
referral or
to his
to
truck,
vet an attorney
which
you're
was
looking at.
parked in front of his
It's
porch.
very
Do
difficult
you
for the normal
recall
layperson to
saying
evaluate
those
whether someone they're
exact words?
considering to
Um,
represent them
I
is
can see that I wrote them, so now I recall.
capable of
sending
doing
this
a competent
to my
job.
boyfriend.
in a
Yes.
better than that,
Your
an excellent
boyfriend and
job,
your dad.
a world-class
correct?
job is what you want.
I don't see if there's an expert. Yes, they're both on that same thread, correct?
She is.
And-
She's coming across as horrible and a liar and a witch
Do you recall
and a
on that
sociopath.
day, and I'll refer you to
So what?
4493,
How is that
Judge, I believe
relevant
at
to
sidebar, we
the?
talked about this was going to be used for impeachment when she said that she wasn't scared of him, not for substantive evidence. So I think the point has been made there. I don't know that it's necessary to go through every text message.
That was your representation, Mr. Blankus.
fine, Judge.
I wonder if this defense attorney knows
Would you
he's
agree
making a
with me that
representation
on
to the
this
court
day
when he
you're
makes a
referring
representation to the court. Just like
You were not
I wonder
afraid
whether
of
he knows what
Michael
hearsay
Barisone.
is.
No, I was afraid. I just
It would be
don't
true to
think
say that
anybody
many
was
lawyers
scared.
and judges don't
And
really understand
I-
hearsay in terms of
if
every
that's what I
nuance of
texted,
hearsay. It can
It was
become
either
a
just what I
very
texted my
rapidly a
boyfriend
very
and father,
complicated area of the law.
Or
But the notion that an out-of-court
those actions
statement's
happened
not
in that
admissible for the
sequence.
truth of the statement
But I
in court
remember feeling afraid,
is at
and
the
he
very
came to the house.
the very base
Came
of
at
hearsay.
me,
You have to
and no one
understand
else was there,
that. What can get
and
complicated is the exceptions.
If
But he
my
didn't
action
state
was
an
to get
exception.
up and be back in his face, hoping maybe that would get him to go away, that was my action. It wasn't the first time he had done it.
The fact that a Jersey girl was being aggressive in a confrontation with a male she was angry at, I don't think is going to surprise any member of this jury.
All right, let's go to the day of the incident. I'm going to give you a copy of your transcript. That's not good. Thank you. May I approach Judge D200G? I'm going to give you a copy of your transcript.
This guy
because
does remind
I'm
me
trying
of,
to save some steps.
If you remember my cousin Vinny, there were initially two defense lawyers, right?
On the day
One of
the
them got
shooting,
fired pretty quickly. This guy does remind me of
you recall
the
Michael Barisone
fired lawyer and my cousin Vinny.
arriving.
Yes,
And is it your testimony?
And yes, there are a lot
that
of
you had
exceptions to the
no
hearsay rule.
idea
But if you're going to introduce something
why
that
he was coming down?
walks and talks like
Yes.
hearsay, you better
Correct.
have your
That is my
exception in
testimony.
hand because you'll be called on it.
How was he driving?
What does that
he was
mean?
driving. He was driving down a driveway, kind of the way he always drives, like a little crooked, all over the place-ish.
Like a little
Did he
biatch?
describe his driving to the prosecutor as like a crazy person?
Kind of the way he always drives, so probably did say that.
Can you please look at your transcript, page 5,
Sure.
Again, this
lines
is
6
all.
and 7.
I mean, this is painful. She's essentially
tell me
agreed
whether
to
or
a
not
largely
that
irrelevant point,
refreshes your
and now he's going
recollection as to whether you
to take
told
all
the
this time to
I
refer
think
to
she
the
just did that,
transcript,
Mr. Blankus.
and again chastised
She
by the
just
judge.
acknowledged that.
Not definitively, Judge.
Yes, she did.
See,
Right.
Yep.
I'll move on. Now, how did he park?
Meaning like what position or in what type?
What were your observations of him parking?
I don't recall exactly because I wasn't paying attention to all that. I saw him pull in the driveway, and then I went to go upstairs to get my boyfriend. So I'm not sure if I actually,
Can you imagine what
Witnessed
Borkowski
him
would be doing to this
working.
defense counsel
or
at
not.
this point?
And I actually don't think I did.
3 hours into an
I don't-
inept
really
cross-examination
don't
of this
remember.
witness.
I definitely just remember him driving into the driveway.
Mr. Belinkis, we need to take a break for a minute. We're having some, well, we're not taking a morning break. Don't get ahead of ourselves here. We're just having an issue with the recording equipment.
Oh my God, that looked like a defense attorney who was desperate for the morning break. Oh, that's a bad look. All right, so something's going on here. It looks like it, I'll see if I can jump forward here. It was only a couple of minutes. Looks like we're back. I think that must be the court with the microphone off.
Being recorded,
There we go.
and there was just a very small break where there was an issue with it, but it's been resolved now. So go ahead, Mr. Belinkis.
Ms. Kanarek,
Yes.
when you saw Michael Barisone driving his truck down the driveway and pulling into the parking area in the back of the house,
Mhm.
were you concerned?
Yes.
Did you think something was wrong?
Yes.
What did you think was wrong?
I didn't know, but I knew something was wrong since it had not been a good week. Tensions were high, and now all of a sudden, he's driven all the way to our apartment for some unknown reason. I'm out there by myself on the porch. I did not feel comfortable or safe to the point that I had to run upstairs and make sure my boyfriend would come down with me just for safety reasons.
Did you think that something was wrong because of all the things you and your boyfriend were doing to him?
It could have added to it.
And based on what you knew about what you were doing, you were concerned, correct?
I mean, if I were this defendant, I'd be looking
question was
that
confusing.
morose, just
When you see
watching
Michael
defense
Barisone
counsel
come
here.
in, he parks his vehicle. You were outside, correct?
I was outside when he drove in the driveway.
Correct.
Right.
And at that point, you go inside to get your boyfriend, Rob, correct?
Correct, yes.
And when you found Rob, he was on the telephone, correct, with your attorney.
Correct.
Now, do you know when Rob called your civil attorney?
No, I do not.
It's so. This is a lawyer who should never go to trial. I mean, if he has to practice law, there's
What
a
did
lot
you
of,
say to
the
Rob?
large majority of legal
He said,
work
"Rob,
doesn't
Michael's
require
outside.
actually going to
I have no
trial.
idea why he's here.
I mean, you can take
but
cases and
He's here
do what you can,
don't know
and when
why.
you realize it's
We
going to
haven't been
trial,
speaking
refer the
for days.
refer the
minutes,
client
or text,
to
even
someone who
about
can
a
actually
fire
work in a
hazard.
courtroom.
And he's now in our driveway, temper problem that we've seen over the course of the time we were there. So that's what happened.
Okay, so you stay inside and Rob goes outside to talk to Michael Barisone, correct?
Incorrect.
Okay, what happened?
I went to get Rob. He came outside to the porch.
So you,
We were both on the porch. for
asking
a
what
moment.
happened in an open-ended manner
Robert,
like this is always
I don't remember
hazardous,
if exactly.
and it's completely
entirely
unjustified
left the porch.
risk to the
or
client
he was just,
unless you have
like,
a
sort of
rejoinder
reluctantly,
ready to counter,
like
impeach,
on the
whatever this
stairs,
narrative
weird.
is.
I don't
You've just
remember
invited
exactly.
this hostile witness to tell the jury about
I
your
can
client.
continue. So Michael,
This is insane.
says
So
to
now she just
Robert,
gets to tell a story to the
how do we
jury.
fix things? Like, I'm sorry, I don't want to war.
Is that story
How do we
likely to
make
be
everything
favorable to your
better?
client
To which
or
Robert
unfavorable to your
replied,
client?
Michael,
Jeepers.
you want to do that? We have lawyers involved. You have a lawyer, we have a lawyer. Let them talk and handle it this way. He then came back to the porch,
Was Michael calm at that point?
completely calm.
Would you describe him as sorrowful?
Yes,
B. Ivory is better than
Now-
this defense attorney. I mean, on the practical
you looked
merits,
at
maybe
your
not better in
boyfriend's
terms of being an attorney, but at least
transcript
B. Ivory
of his
brought
testimony?
theater to the
I have
courtroom.
not.
Have you talked to your boyfriend about this incident?
Yes,
Did you talk to him last night about this incident?
probably, but the shooting itself, we always talk about that. It's a lifelong, life-changing incident to have someone try to murder you. So yeah,
So yeah, if she's talking about what her boyfriend told her, is that hearsay? And yes, if she's repeating, yes, it's hearsay. But we work in an adversarial system in court. So somebody would have to object to the hearsay. I mean, the judge isn't really supposed to do that himself. The other party's supposed to object. And this woman's hearsay is favorable to the state. And she's being questioned on cross by the defense. So if the defense solicits hearsay, it's going to be damaging to his client, and the state has no interest in objecting to that hearsay. So of course the state will just sit there and twiddle their thumbs and enjoy the show.
yes, probably.
Now, at that point, after that conversation with Michael Barisone and your boyfriend, isn't it a fact that your boyfriend walked inside the house?
In
Well,
theory,
exactly.
the
Yeah,
judge
he
could
does reach
object to
that
the hearsay
out.
on his own initiative, but this judge,
Please
they're
listen
not
carefully.
required to,
Yes,
and
they
this
are.
judge is too busy writing whatever angry letter he's
Isn't it
scribbling
a
away at.
fact that after your boyfriend had that conversation with Michael Barisone, he walked back into the house?
Not directly.
Angela, very
No.
kind of you
When did
to
he
thank
walk
me for
back
explaining
into the
hearsay, but believe me, hearsay, we could
Um,
spend a couple hours on hearsay
After the police was there, were
and still
there,
not cover every nuance.
and I guess separated Barisone and my boyfriend, he opened the door to put the dog into the house.
Now, the fact that your attorney may be a bad attorney
That's
doesn't
when
make
he
him
means.
constitutionally ineffective for an ineffective assistance of counsel claim.
After your boyfriend is done talking to Michael Barisone, you
And in
come
any
out,
case, if we're
correct?
thinking about an appeal,
And then he
appeals
went on the
are
porch,
for
and He's then on the
losers.
porch.
And how would you describe your demeanor at that point?
Oh my God.
Interested,
Well, do you recall telling the prosecutor that you walked out thinking I'm like Miss Badass or something? Your exact words to them.
First of all, her
No, I
state of
don't
mind and
recall
her
that. Do you
demeanor
have
are
the
two
date
different
of that by
things.
any chance?
It's the transcript in front of you,
Mhm.
September 5th, page 6, lines 5 and 6.
Was it page 6?
Page 6,
And the date,
line 6
sorry.
and 5.
Page 6.
And again, folks, I think any defense attorney in
Again,
this
this is
case would
September
have an
5th,
uphill
right? So
fight. I mean, this
I'm
is
just
a
trying to-
difficult case. But you can have a difficult
Page
case
6,
and a
line
competent
6.
legal defense.
So, oh
You
my
don't
God,
have
I
to
wish
have an
change that.
incompetent legal defense
Just
just
read it
because
to
you happen to
yourself.
have difficult
Yeah,
facts.
just read it to yourself to refresh your recollection.
Yes,
Did you come out like Miss Badass? Yes or no?
no,
Did you tell the prosecutor that you came out like Miss Badass?
I tell them that I walk out thinking that
Right. So
I'm
state of
like
mind
Miss
and
Badass
demeanor,
or something
the outside
for having
presentation
even
of your state of mind are two different things.
what I would consider now the courage to even approach him at all.
Who is Miss Badass?
As a character, I don't know.
At that point, were you like sick?
People
of
often
this?
shoot each other for irrational
Yeah,
purposes,
so I'm
folks.
still
So he may have just shot
saying-
her because
I
he was acting
sick of
irrationally.
everything
He was
that
angry.
Going on that week.
These things happen all the
So,
time.
Again, I was interested, as I said before.
It doesn't
in
really
what
matter
was
why
said.
he shot her unless the reason can be justified.
Now, what do you recall Michael saying to you?
He said nothing
You
to
know,
me.
he shot her with the gun. It's
I
presumed
spoke
he
first.
intentionally wanted to cause
Once
her
I'd seen or thought that there
death
was no
or serious
danger,
bodily injury.
having seen Robert just speak to him,
If he wants to provide a
and
different
come back
explanation, he's
to
got
the
to provide put
unscathed,
forth a prima facie
I
case
then
of
felt
self-defense, and then the
safe.
state has to disprove that
have a conversation
self-defense
with this man.
justification beyond a
Did you
reasonable doubt.
speak
But
loudly
that doesn't
enough
look to me like a difficult
where
challenge for
your
the state so
boyfriend,
far.
Rob, would hear what you said?
Probably, I would think so, but I can't know what he heard I said or not.
Okay, what did you say
I don't think
to
anybody
Michael?
could help this attorney. I have to
Something
be
along
honest.
the-
I mean,
I don't know the
sometimes you
exact
see
words.
a competent
along
attorney
the
who's
lines
kind of
of,
wrapped up in their
"Okay,
case,
Michael,
and maybe
how do you
they're
plan to fix
missing
this, and
a
how are we
particular
going to settle Rob's?
argument,
I was about to
a
say the word,
particular
bill,
perspective on
but I
the
don't think that
facts,
ever came out of my
or
mouth.
there's a
because-
line of legal reasoning that
was
may
like
not have occurred to
mid-word.
them. I mean, nobody's
Right
perfect.
then,
Even the best attorneys
I said
sometimes,
maybe a
miss
sentence, less
something.
than a sentence.
And if it's a competent
and
attorney and they're just missing
right
something
then,
and you bring
it
it
was
to their attention, they'll be like,
out
oh,
of
holy
his
shit, I
pocket.
can't believe I didn't see that.
Boom.
And they may well pick
Boom.
up that weapon to use in
Period.
court.
He runs around the
But
table.
you have to be competent in the first
I'm sorry,
place.
excuse me, I messed that up. Boom, boom. Then he raises his hand up to where Rob was standing on the porch.
And people
shoots
keep
at
asking
him.
about the other defense attorney.
The
You know, I
trajectory
mean, there's
in the
lead
head.
counsel and second chair. And if
And
that guy's
I then
second
do
chair,
not
it's not
see
up to
Robert
him.
anymore.
It's up to lead
I see
counsel
Michael
who's doing all this.
Run around
And for all
me
we know, that other
and
guy's
up
even
the
worse.
stairs, straight to where Rob was no longer. And that is what I saw at that.
And yes,
exact time.
I still have the beard.
Is it your sworn testimony that you saw the actual gun before you heard the discharge? Did you see the gun, yes or no, before
Discharged.
the discharge?
Yes, I did.
Now, you indicated yesterday that after getting shot,
Mhm.
in your mind, you just ran around in a circle in your mind, correct? You recall saying that yesterday.
I don't remember what I recall from yesterday. I remember we discussed,
That
I
nose
remember,
wiping is a bad look.
didn't know
That
really
looks
where I
like
was
a
disoriented.
1980s cocaine
I
habit
know I
right
ran
there.
around in an actual circle.
But when you mean an actual circle, that's different than what you testified to
That's
yesterday.
not
No, no,
It's not-
Mr. Belinkus, don't characterize the testimony. It's the jury's recollection that counts here, not yours.
Did you run around in a physical circle?
Yes, in a physical circle.
And did you run around in a circle in your mind?
I mean, this defense
Probably
attorney
many
just doesn't
circles
present
in
as a
my mind.
defense attorney. He presents as if they had bumped into each other, into this witness at a restaurant,
Where
and
did
he
you
was
go when you
the
were
defendant's
running around?
buddy, and the buddy is chastising this woman who's treating his
In
friend
a,
poorly. Isn't it true you
I
did
don't
this,
know.
that, the other thing, and blah, 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 blah.
Demonstrate. if you'd
But
like.
Yeah, please.
that's not how cross works in court.
Can I take my shoes off because
Sure.
I wonderful.
Yes, go ahead.
So Michael is standing here, shoots me, and I then see him raise his hand, shoot at Robert's head. I look at my chest, and where do you go? What do you do? The circle I ran around was like this,
Okay,
in that area.
okay, perfect.
Sorry about that.
Perfect. That was perfect. Perfect for who?
Embarrassing.
She just got to act out how his client shot her for no apparent lawful reason.
Do you recall telling the Morris County prosecutor in your official statement that I took two
Her
in
audio
the
is probably
chest
picked up on the judge's microphone there
And I
because his
just
microphone is cranked up to
see
12.
blood like everywhere, and as I ran, and this is the point where it gets a little shady, because I don't know where the hell I went. Do you recall saying that to the prosecutor's office?
Yes,
Did you show them that little movement that you demonstrated in the courtroom?
I did not show them because I was referring to, I didn't know where I went, meaning in my head. I know where I went, the area where I actually moved around.
Do you recall telling the Morris County prosecutor's office that I went somewhere, I ran, I think I went inside
No, I
to
did not.
yell to Rob? Do you recall telling the prosecutor that about your running?
But I'm running, I did go inside to call to Rob, to bring him downstairs.
You're saying to the prosecutor, you ran inside the house to call Rob after you were shot. Didn't you say that?
If I did, I don't recall. Like, again, it was a few days after being released from the hospital. I was on a ton of pain meds. I might not have even understood half the questions they were asking me at that
Okay,
point.
so let's turn to page 6.
Sure.
So painful.
And before I ask you a question,
What?
when you say you just got out of the hospital
Yes.
and were on pain medications,
Mhm.
you just recently were shown your actual video of this interview, and you had an opportunity to see exactly what you said.
Mhm.
Did you tell the prosecutor that there were grave issues with regards to
I
what
don't, I don't think she said there were grave issues.
I mean, again,
I'm
this
rephrasing
defense
the
attorney
question.
just looks
Please
stumped.
Did you tell the prosecutor that you didn't run in the house after being shot?
He's like,
Like
that's
you
not
said in
allowed.
the official statement?
I'm not allowed to
I'm sorry,
characterize
I
the
didn't
witness's
run the house.
testimony.
Oh, so if you could repeat that, I couldn't understand.
Let's move on. Go to page 6.
Yeah, let's move. How about that? How about we move on to something
Line
relevant.
21.
Yes,
Do you have that?
I do.
And yes, for
You
those who came in
recall
late,
saying,
this testimony
"Because
we're
I
watching
don't know
occurred
where the
yesterday, so
hell
I'm basically
I
a
went."
day behind the trial. I've
And
not
this is
watched
after
it.
the
I'm as
shooting.
naive
You
to
recall
this
saying that
testimony
today.
Yes, I
as
do.
cross as all of
And if
you.
you go down to line
All of you
24.
who also didn't watch it
Do you
yesterday.
recall saying, I went somewhere, I ran, I think I went inside to yell to Rob.
Mhm.
Do you recall saying that to the prosecutor?
I don't recall it, but I see that I said it. Yes, I don't know what it means.
Do you recall after the shooting, running into the house, yelling for your
Yeah,
boyfriend?
insanity defense could be a defense here.
No.
I mean, he mentioned insanity defense explicitly in his opening statement. The defense counsel did. But it's a very, very high threshold, folks. You have to not
Do you recall telling
have not
the
known that what you're
prosecutor
doing
that
was wrong,
the
which
reason
in a
why
practical
you ran
sense means,
to yell to
you know,
Rob
he had to
is
have thought
because
he
you
was shooting
didn't
a
want him
Martian
to
or a
come
robot
out.
or a werewolf, not another human being.
recall
If he
telling
knew
him
he was
that?
shooting another
I'm sorry,
human
could you just
being
give me 1 second? You're speaking
outside
very
of justification,
quickly. I
that's
just wanna be able to make
that's
sure
just
I can read
shooting
it.
another
Again,
person.
if I'm not reading the exact words,
Yes,
bring that to my attention.
I absolutely will. So it's on page 6 that we were.
I don't know the specifics of New Jersey sentencing for attempted murder. Normally, the attempt crimes the sentence is akin to whatever the crime was. You don't get a break for having failed in your attempt, and typically murder is punishable by life in prison without possibility of early release. I'm not sure if that applies in New Jersey or if they have different sentencing guidelines, but it would be something along those lines.
I'm sorry, I was just reading this for context. What was the exact question again?
Did you tell the prosecutor that the reason you ran inside the house and yelled to Rob?
And then, of course, there's the gun
Was-
charge, the separate gun charge, which he'll
For-
certainly be found guilty of.
Because you didn't want
I mean,
him
there's
to
there's
come
no
out
there's no justification for his
outside
unlawful possession of the gun,
where
and
things were going on.
and to whatever extent the
I
gun would be an
did say that.
enhancement factor on the
You know
sentencing.
what
And-
I'm
So,
talking about?
yeah, we
and
talked
you
earlier.
recall
If this were if
what you yelled
imperfect
to him,
self-defense worked here
"Don't
and it was
come out."
mitigated from attempted murder to attempted
No,
manslaughter,
I did not yell.
manslaughter's going to have a range of
Did you tell the
sentencing,
prosecutor when you gave
and a
your
mitigating
official
factor
statement
could be
that you
that
yelled
these people
to
intentionally
Rob,
tried to
"Don't
drive him
come
crazy and
outside"?
apparently succeeded. But an aggravating factor
I don't actually
would
recall
likely be
that.
that he's the
No.
gun to commit the offense.
I
If
see
you look on
that,
page 7, the
Yep.
first line, does that refresh your recollection of
It-
you telling the Morris County prosecutor?
it refreshes words that I was saying, yes.
Okay. Did you also tell the prosecutor that at that point, Rob was not putting 2 and 2 together, that you
This guy
had
is
been
a former
shot?
AUSA.
Yes.
That's hard to believe.
So will you agree with me that when you
I guess
first
some of
talked
those
to the
guys don't do
prosecutor,
trial work.
Rob,
Judge, I'm going to object on speculation grounds. I mean, I understand why the detectives ask her these questions,
Right.
but it doesn't make it admissible evidence. He's asking her, what did Rob Goodwin know?
Yeah, I'm not sure I understand
No,
the
I-
question. I mean, the words speak for themselves.
okay.
Rob, they're referring to
Did
Rob.
you
Rob's
tell
her
the
boyfriend
prosecutor
who was shot at by
that
the
Rob
defendant. That's
heard
the
gunshots?
he's the victim
Same
in
objection,
the
Judge.
for the second count of attempted murder.
Yeah, I mean, where would she get that information? Other than from her boyfriend, making it hearsay. Sustained.
Yeah, I mean, obviously, if he was a AUSA, he would have been a prosecutor. Of course, that's what that means. And you know, I mean, the
At
federal
some point in
prosecutors have
time,
conviction rates of trial of like
Rob
98% because
Jumps
they
on
get to
Michael
pick the
Barisone,
cases they
correct?
bring, and a lot of those
Correct.
cases are easy
Were
cases.
you outside?
I was.
I mean, especially, you know, if they're child porn cases or drug cases or gun cases, they're all possession cases. And if you lock in the possession, the rest of the trial just kind of falls into place. There's nothing very complicated to do. You get the conviction. So if that's how you spend your career,
Did you see
you're not
Rob,
really a skilled
choking
prosecutor. It's like
Michael
you're a
Barisone?
weightlifter who only ever lifts
I saw,
5-pound dumbbells. I mean,
He had his
and then suddenly
arm
you find yourself at Venice
behind his
Beach.
back,
It's going to be a rude
and
awakening,
he had
especially
him
for
in
your
some kind
clients.
of- like a headlock to restrain him from being able to get the gun.
Speculation grounds are when the
What do you
lawyer's
say?
asking the witness, well, to
Would you
speculate
describe
about,
your
you know,
observations
so why do you think that
in a
was?
choke?
They don't actually have personal knowledge
Maybe.
of what you're asking them about. They're just
I don't know
guessing.
like exact terms of these things.
Okay, when you say you don't know exact terms, on the day of your official statement, on page 8, line 6, did you describe it as a chokehold?
Probably.
Can you look at it and tell me
Same
either
page?
yes or no?
I mean, yeah, I'm
Eight.
sure I said it.
Line 6,
Page 8, line 6.
yes.
You would like no problem.
I see someone mentioning that lawyer,
uh,
you know, I don't know who that is. I guess it's a
in
YouTube
like a
channel, is
chokehold.
interviewing the Curtis
So,
Reeves
yes, I-
defense team today.
In like
Um,
a chokehold.
And your boyfriend
Curtis
is
Reeves
an
got acquitted.
ex-Marine, correct?
Probably ought to have been acquitted. I certainly don't have any problems with the acquittal. I think it was a marginal case, frankly. And there were times his defense attorney did a great job. They did a much better job on cross-examination than this guy, for example. But their opening and closing statements in that Curtis Reeves trial were
At
horrible,
this point,
were just awfully bad, which is why I never get to interview these attorneys
Did you
because
start attacking
who wants to be
Michael
interviewed by
Barisone?
someone who thinks their opening and closing statements
At
were
which
horrifically
point?
bad for their
I'm sorry,
client,
could you?
regardless of them getting a good
Let
outcome.
Let me back up a little bit.
Yes. Thank you.
When you're talking to Michael Barisone and you're saying he's firing the shots at you,
Mhm.
you were on the phone with your civil lawyer, correct?
Well, I mean, I'm sorry, I just, I guess I have a question. If I could
No.
ask it.
Do you understand the question or not?
No,
All right,
because it's all-
rephrase your question.
at the time you were talking to Michael Barisone,
Mm-hmm.
and when you say the shots were fired,
Mm-hmm.
you were physically on the telephone talking to your civil lawyer, correct?
I was physically holding the phone and talking to Michael Barisone.
Okay, but your lawyer was on the line, correct?
Yes,
And whose phone was that?
Roberts.
So can I assume when you
She
took
just
two
gestured.
shots
Is
into
Robert
the
in the
chest,
courtroom? He can't be in the
you
courtroom.
dropped the phone?
I
No,
believe he's the
I didn't
next
drop the
witness. So normally,
You
Not,
kept-
not that,
except
sorry,
in
not that I
strange
recall. I do not
situations where
remember
they might be
dropping the phone.
family
What do you
members of the
remember
defendant, normally they're not
doing-
allowed in the
doing
courtroom.
with
Or
that
future witnesses or any
Honestly
witness that
forgot
might be
I had it in
recalled
my
because you
hand.
don't want their recollection or
Totally forgot
testimony
that
to be
Ed
tainted
David was
by
still on the
other
phone.
witness testimony.
At some point in time, you start beating Michael Barisone with your phone.
Correct.
Did you have two phones in your hand?
No.
What did you do with the phone, Robert Goodwin's phone,
Mhm.
after you were shot?
I told Ed David, oh my God, oh my
I'm not
God.
asking you what you
Oh.
told him. What did you specifically do with the phone
At what point in time? Let's specify
after
that.
being shot?
Can you just repeat that whole question? I'm
Absolutely.
so sorry.
You're holding the phone
Yes,
where you were having a conversation with your civil lawyer, correct?
yes, correct.
Okay. You claim you got shot at that point, correct?
Correct.
Okay. What did you do with the phone that you were holding after you were shot?
I believe I just kept holding it.
At some point in time, you picked up your telephone, correct?
Correct.
Where was that telephone?
That was by the door. That was not the door to the laundry room, which is now like semi-open, which was from Rob jumping through the door to avoid being hit in the head with the bullet. So my phone was somewhere right around there.
Okay, so let me stop. We'll go in
Yes.
small steps here.
Yes, sure.
So it's your testimony that after being shot 2 times in the chest, out on the patio by that round table, correct?
Wait, I'm sorry. That was confusing. Could you say that one more time? I'm so sorry.
Okay. Where were you shot?
I was shot. Is there,
Why introduce the round table? I mean,
The
this is,
location on the
Yes,
porch or on the
location on
body?
the porch.
Let's specify.
he makes his
I'm
question
gonna-
so complex
show
with
you
details that are not
the
relevant
800.
that it just creates
Great.
confusion, or at least the opportunity for this witness to act confused.
Can you put a big X? Does this accurately depict the area where the incident occurred?
the area? Yes.
What's that right there?
That is a camera in
Okay.
the window.
Now, can you put a big X where you were standing when you got shot?
Sure. It's a little hard to do because
I'm
everything's
still in
all-
pain from my gunshot wound.
I guess,
Just do it to the best you can.
I was standing. I don't need to highlight that.
Okay,
Or different color pen,
and let me try.
whatever's.
So the record is clear, and this mark is faint on D803, but you can see it. You put kind of like a star.
Yep.
Basically right next to the metal table and chairs,
Correct.
okay?
The metal table and
that's-
chairs. What's the point here?
That's where you say you were standing when you got shot, correct?
That is correct.
And from that round table and chairs, you walk all the way to the back steps after being shot, climb up the stairs.
Now the defense lawyer is
get
role
your
playing
phone.
the shot victims
Yes, I wanted to call
staggering
911.
around.
Is there any reason why you didn't use Rob's phone that you already had in your hand?
Well, for one thing, I wasn't even thinking that I had it. When I did realize, the first thing I did, I think the first thing I did was let the person I was on the phone with know, oh my God, I've just been shot.
Right, I'm not asking you that.
Okay.
I'm asking you what you did with the phone. Okay?
With the phone
me-
that I was on?
Right. So the phone that you were on,
Yes.
at the time you claim you were shot, after you're shot, it's your testimony that you walk all the way over to the stairs, climb a flight of stairs, and get your telephone, correct?
More crawled-ish to there.
Crawl.
Yeah, I wasn't exactly like running. I was losing a lot of blood.
Okay.
So, yes, but I know you didn't ask if I crawled or walked or just what I do with my phone, with the phone.
All right, so what did you do? What hand were you holding the phone?
I'm right-handed, so I would think my right hand.
Okay, so what did you do with that phone?
I think after I told David what had happened, I think I just like placed it on wherever the porch area that I was then on. And for some reason, yeah, that's what I would say.
And you didn't use that phone to call 911, correct?
Correct,
You looked for and found your own personal phone, correct?
yes.
And then when you found your phone, did you come back down the stairs to the area where Michael and your boyfriend were struggling on the ground?
When I found my phone,
After I'd been shot
I
twice in the chest by your
tried
client.
to call 911. I couldn't because my arms and my hands were covered in blood. The phone would not open.
Okay.
So, what was the second half of your question?
How did you call 911? You're the person, the first person on the 911 call, correct?
Yes, I then remembered, oh yes, Robert's phone is out here. I'll use Rob's phone and call 911, which I did too.
Okay, so let me get the scenario correct.
Oh my God.
Mr. Malinkas, we don't need a summation now. Just ask your questions. All right?
I
What
guess
did you
law and
do
crime would say
with
this
your
is the judge
phone
being
at that
biased and
moment?
unfair again, folks. This is just the
I'm
judge
sorry.
being the judge. He's just
At the
doing his
point-
judge job.
When you realized you couldn't call 911
Mhm.
and you decided to get Rob's phone.
I put it back down
Again, for those of you who
Put it
watched
back
the
down where?
Theodore Edgecombe
wherever I
trial,
picked it up.
just
from,
imagine
like I
Judge
described
Borkowski
a moment ago,
sitting at this bench.
near the door by the laundry room, which was also next to where the love seat was.
This defense lawyer would have been
So-
burned to the ground.
You came down the stairs with your phone to where Rob and Barisone was struggling. You tried to call 911, correct?
Incorrect. I went up the stairs to get my phone and tried to call 911 and my phone would not open. I then put my phone back down. And
Where
then,
you put your phone back down on that landing?
no, my memory, in my memory, I remember putting it back down right where I picked it up, which was somewhere on the actual porch. 'Cause that's where it was. Put it down,
And then you go and retrieve the phone that you had previously placed somewhere, correct?
yes, 'cause I remember that I wouldn't need a.
And where was
press a
that phone?
button.
Where was that phone?
We're at somewhere near the vicinity of where Robert was restraining Michael.
Okay. And at that point is when you claim you called 911, correct?
Correct.
And
She claimed,
everybody's heard the 911 call.
Yep.
So you're on the phone after a period of time.
Hey guys, I just want to note, I checked and we just broke 30,000 subscribers. We're at 30,009. Thank you all so much. I can't tell you how much I appreciate it. For those enjoying this YouTube video, if you haven't yet hit that subscribe button, pound it like, well, use your imagination, good and hard. And we really appreciate it. Hit that thumbs thumbs up button. Not thumbs like, that's something else, I would imagine. Hit that thumbs up button. Leave a comment, even if it's just with your city and state. First of all, that might inform some of my answers to questions, but also it helps trick the YouTube algorithm into sharing our content more broadly, which we always appreciate. But thank you all so much. It's really humbling. I can't believe we have 30,000 subscribers. That's crazy, but very, very gratifying. Thank you so much.
Mhm.
You hand the phone to your boyfriend, correct?
I think he kind of took it at that point because I had my phone again. And
What do you mean you had your phone?
I went to go, I think I had my phone.
Until there's evidence
Because-
that
Didn't you
Well,
just,
Michael
Strike
Barisone was
didn't
attacked
you just
or
indicate that
threatened
you
with
placed
imminent
your
attack
phone
prior,
back on the
immediately
landing?
prior to his shooting
back in
them
the area.
and at them,
Like, to me.
she doesn't have to lie
where
about
they were
anything.
Having their,
If she mentally
where
tortured
Rob was
this guy
shooting
until he
Michael.
broke and shot them,
in my
it's still an
memory,
unjustified
I do not
shooting.
remember if they were actually like still on the porch or just 2 steps below on the landing. It was just,
Didn't you say yesterday they were off of the landing, off the stairs,
I believe
on
I-
that concrete
I
patio?
believe I said I wasn't sure that there were 2 stairs.
Okay.
So we can go back over it if you'd like to.
She can sit in this witness stand
But
all
what I believe
day,
I
and
said
she
is the
has,
same thing I'm saying now.
and multiple days,
which
and
is
she
that I
has,
don't remember
and
if they were
acknowledged with
actually
every
on
question, yes,
the
I am a
porch
malicious,
flat
vile
area
bitch,
Or like.
and I
a
deliberately
step or
sought to
2
destroy
below
this man's
on the patio. I
emotional
don't remember
state, mental
exactly
state,
Okay.
Where that was.
reputation,
You
career,
can correct me if
everything.
I'm wrong.
And none of that
You
would
call
justify his shooting of
911.
her.
You have a discussion with them, and then Rob has his phone back, correct? A 911.
I see
After
FN
spoke with
lawyer,
them,
Right.
which is very
Used to
brief.
cover Hampton
Yes.
Roads, Norfolk,
And
Virginia
is it
area.
your recollection
I got a
that
speeding ticket
after
once there.
Rob took the
I would have
phone
called
from
you.
you,
Oh, maybe.
you walked
I actually
up the
did have a lawyer
stairs
represent me for
and
the
got
ticket.
your phone
Maybe it was you.
again.
Who knows?
I didn't walk anywhere. There is a point that I went and got my phone
When was that point?
Well, let her finish, Mr. Belenkus.
somewhere in between after I told 911.
So I haven't watched every witness in this trial, just her, really, for her cross. And of course, the key question is there any evidence that Michael Barisone was attacked or threatened with imminent attack immediately before he fired those shots in purported self-defense? I did watch the opening statement of the defense, and they never said that. They never said that he was threatened and then fired the shots. If they're not going to say that in their opening, does that evidence exist? I mean, if it exists, even if it doesn't exist, wouldn't they make the claim in their opening? My client shot. Why did your client shoot these people? That's what the jury wants to know. Well, they were threatening him. He didn't shoot until they were threatening him. But that was never said in opening. So I have my doubts about whether or not such evidence exists.
I'd been shot. Rob was, you could hear him struggling with Michael. At that time, I grabbed my phone. I was covered in blood. I crawled somewhere, whether it was an inch away or half of a foot away, to get my phone, thinking the only way that
I don't
could
get
help
speeding
the
tickets often,
situation
folks, and
is
only
by
ever
helping
on the
to make sure
motorcycle.
no one else gets shot or killed that day.
But thanks for the offer of
Which
support.
is-
I appreciate it.
Why I had my phone and was hitting Michael on the head with it, or you with it.
How long were you beating Michael Barisone with your phone?
Maybe a matter of seconds.
You're sure of that?
Pretty sure, yes. I didn't have, yeah.
In their opening statement, the defense
Definitely.
mentioned,
Sure.
referred explicitly both to the insanity defense and more ambiguously to self-defense. nothing this woman says is going to have much to do with an insanity defense evidence for that. That'll have to come from a psychiatrist and
Do you
psychologist.
recall previously
And the defense
saying
does have both those
that you
professions
used
lined
your
up
7
to
minutes
testify
to
during
help
their case in
Rob
chief.
by keeping the
but-
6'4"
but I don't see it. It's a very, very high
MP
threshold
subdued by
insanity
breaking my
defense.
phone in his cheek and in his ear. Do you recall saying that you were beating him for 7 minutes?
I did
That's not, wait a
that's
second,
not-
Mr. Belinkis. That's not what it said.
Okay,
Let's not, don't characterize things.
Okay.
Ask a question. If you're reading from something, read the specific words. Do not characterize it.
See, this is something this defense counsel has done repeatedly throughout this cross-examination. He's misreading her prior statements in front of the jury. And it's gotten to the point where the state has objected before. And sometimes it's just, small word changes completely change the implication of the statement. And it's gotten to the point where obviously the judge could have called him to the bench and said, you can't do this, but the judge is fed up. This is not the first time this is happening. The judge is not going to allow you to misrepresent evidence to the jury. If the statement says A and you read it as A prime, something different than what it actually says, you're going to be held to account, or you ought to be held to account. The judge has a duty not to allow the evidence to be misrepresented to the jury.
okay. Did you say these exact words? I used my 7 minutes to help Rob keep the 6'4" MB subdued by breaking my iPhone on his cheek and in his ear.
I'll have to
Oh,
keep an
is that
eye on
that?
commenter Jim
7
Satala.
minutes you
He writes,
claim
let's see,
to
can I
be
put this up?
beating Michael Barisone.
Who are you,
Isn't
Jim
that
Satala?
correct?
That seems a
We
pretty
just put that in
biased
context.
perspective
Yes.
from my point of view, based on
Oh,
my
you can
experience.
do that on
We'll
redirect.
see how your
That's what
company
redirect is
goes
for,
moving
Mr.
forward.
Sherman.
Did you also tell everybody that you were medevaced in a helicopter?
Yes, I did.
That never happened either, did it?
I didn't learn that until literally 2 weeks ago.
Okay, my question is,
I think she answered the question, Mr. Belinkis.
Again,
What's
why
your
is he
question?
stumped? Why is he stumped?
that she wasn't medevaced in a helicopter, which is inconsistent with her statement. Her saying, I just learned that.
This
not
is
a
so
direct
far from a
crime.
judge being harsh,
it
unreasonably
again.
harsh. It's beyond imagination that any informed person could think that's the
You
case.
said you were medevaced in a helicopter,
I
correct?
did, yes.
You weren't medevaced.
Maybe
by
this is some of the
helicopter,
long
correct?
crime crowd
As
coming
turns
over.
out,
Who
that is
knows?
correct.
And when you say
This
you
judge
just
is being
found
almost
out 2
shockingly
weeks
polite.
ago,
Mhm.
that was when you went over your statement with the prosecutor, correct? The video.
Correct.
Okay, and you corrected that statement, correct?
What
You
do
had an
mean?
opportunity
What do you
to correct what you said on that video, correct?
mean? I'm sorry.
I'll move on.
If you don't mind.
Now, did you indicate to the prosecutor that with regards to that point of time, when you start hitting Michael Barisone with your iPhone, that your boyfriend, Robert Goodwin, was not even aware that you were shot?
Objection. Calls for speculation.
I'm referring to her statement.
I know,
because it's
but
in
the
the
information she
statement doesn't
gets
mean
in
that
the
she can
statement, it's
testify.
hearsay within hearsay. Sustained.
Now, do you recall bashing and bashing and bashing that guy's freaking ear in with your phone?
I do.
This defense is not being constrained at all, folks. I
Do you
mean,
recall that
except when they go completely outside the
During
boundaries.
that time, at some point,
We have
Michael
rules for a
Barisone
reason.
was unconscious.
No, I do not recall that.
Can you please look at page 10, line 13, and ask me if that refreshes your recollection as to whether or not during that time, Michael Barisone
Remarkably enough, the
was
defendant looks
unconscious for
shockingly
a
less
few
crazy with
seconds.
glasses on.
What line on page 10?
He looks almost normal there.
Line 13.
Yes, this was my perception, but I had no way of knowing.
If she was smacking Michael Barisone around with a cell phone
And-
before he shot her, it would not
With
justify him
regards to
shooting
your
her.
hitting Michael Barisone in the
That's
head
not
with
a
your
deadly
phone,
force attack.
Did you stop at one point and then start up again?
I wonder what he's writing.
Yes, very quickly.
When you say very quickly, what was the time period between when you first started?
What she's
to
describing now, the shooting has already happened.
dash
She's
your
been shot
phone
twice in the
into his
chest.
head
Yes.
in relationship to the second time you started doing that?
Pretty much the first time I did it, you did it one time. And then my boyfriend, once, this is what he told me, he saw a
You can't
giant,
say what someone else
oh, I'm sorry.
told you.
Anyway, my boyfriend, realizing the damage, had tried moving me, or like kind of,
Yeah, I have to be honest,
Making
folks.
me
If I were this
not
defense,
be
I
where
would
they
I would
were
be pushing
so that I
imperfect
wouldn't
self-defense
just, I
with
guess,
both
fall over
hands
and
as
die.
hard as I possibly could.
so,
I would basically
but I
concede.
didn't want
Listen,
to, I was worried again about the
Concede's
gun
too
going
strong a
off.
word.
So I thought when I came back,
If you think you have
and
something
tried
to
to hit him
support
again
self-defense as a justification, I guess you go
And
with
then I
it. If
just
you think you
walked
have
right
something to
in.
support insanity, I guess you go for it.
any
But the
adrenaline
fallback
I may
position
have had
is going to be
just
imperfect self-defense.
died.
Even if you don't believe my client was insane in the legal sense of that meaning of the term, even if you don't believe my client's shooting of her fits within the boundaries of lawful self-defense, it has to be imperfect self-defense. It has to be a genuine but unreasonable belief in the need to fire those shots because of the intentional, malicious, monstrous way in which these people sought to destroy my client
Now,
mentally and psychologically. They tell you in their own testimony they
during
sought
this
to do
time,
that, and it worked. They were successful,
what did you
and
observe
that
your
ought to
dog
mitigate
doing?
my client's criminal liability from what would otherwise be murder
Which
to manslaughter.
time?
You're not letting him out on the streets, folks. If you convict him of,
Your
find him
boyfriend
guilty
is on top
of manslaughter.
Michael Barisone, and you're hitting him in the head with your phone.
Same answer as before, which is I witnessed her nipping and
I mean, sometimes you
pretty
just
much
have to tell your
nipping both
client,
of
look,
them,
a win
in different
here
areas and
is
barking.
manslaughter. That's a huge
Or
win.
yeah.
It was during the time when your boyfriend was physically struggling with Michael Barisone, and
Yes.
you were hitting him in the head with your phone.
Yes,
This is not from a few
Are you
days ago, folks.
sure
This is
that-
her testimony from yesterday, but it is recorded
That
from
didn't go
yesterday.
on before any shots were fired?
Then what go on? You gotta clarify.
The beating, the talk by the dog, and her slamming her phone into his head.
Yeah. So another sidebar, because obviously what this defense lawyer would like to have in evidence is that all this happened before or concurrent with their client firing the shot, that he fired the shot to defend himself against her attack with the phone, which is ridiculous. The boyfriend's attack, all right, well, maybe. The dog's attack, except he didn't shoot the dog, I don't believe. But if it happened after, if their use of force upon him happened after he shot them, and there was no occurring or imminently occurring threat from them prior to his shooting, that can't justify the shooting. Arguably, they're defending themselves from being shot again. All right, is that the, let's see. All right, that's the end of that clip. Good news, folks. I have a second clip. What she shot point blank. Point blank is one of those weird things. It's not really a technical term per se. She was shot at close distance with a handgun for sure. Okay, so there's a pause there, and we come back. Let me take a quick look to see if there's any super chats that need to be answered before we move on. In fact, let me open up the live show for the Law Self-Defense members and see if there's any questions from the Law Self-Defense membership. They always get priority, as you might imagine, and thanks for their ongoing and continual support. All right, let's see. David's here. Good to see you again, David. Robert's here. Awesome. Let's see. David writes, this morning when we started, I hope the defense gets better, but it seems like they're terrible. Yeah, well, David, so far they're terrible. Let's see. David says, my cousin Vinny is awesome. I think my cousin Vinny may well be the best legal movie ever produced. It's fantastic on the legal merits. And of course, it has the female lead is quite attractive. Yes, so Robert also asks, Law Self-Defense member, Robert asks over at the Law Self-Defense member dashboard, do I know if the defense has designated an expert witness to testify with regard to diminished capacity? They did say in their opening statement that they have both a psychiatrist and a psychologist lined up to testify as expert witnesses, presumably for purposes of an insanity defense. Or at least some kind of, diminished capacity offense. So, I mean, there are a variety of ways we could get to manslaughter here, attempted manslaughter here. One is imperfect self-defense, which I've already talked about. Another would be a more traditional path to manslaughter, which is called, sufficient provocation. The classic example of that is when somebody comes home and finds their spouse in bed with a lover and shoots them both dead. The shocking discovery that their spouse is unfaithful is deemed to be sufficient provocation, that it stripped them of the ability to form the intent to kill required for murder. It basically is just saying, listen, sometimes people see things that are shocking enough that they're not in their normal state of mind. So it's different than cold-blooded murder or even angry murder, absent that kind of provocation. So you might argue that the torturous way in which they treated this defendant over such a long period of time qualifies as sufficient provocation to mitigate attempted murder to attempted manslaughter. So there's a variety of ways to get there, and you would want expert witness, psychiatric, psychological testimony on that point as well. So I expect we'll see that if when we get to the defense case in chief. All right, and now the super chats, just to catch up before I start the next. Let's see. Oh, there's uncivil law. Sorry, dude. I'm just seeing your comment here now. Kurt, I'll send you an email with the link to join us. If you'd like. I don't know if you're still around. My apologies. I didn't see that earlier. Let me nope, that's not the right Kurt. Let's see. Always happy to get one of the other fellow law troopers on, if they would. All right, Kurt, so if you're around and you'd like to join in, happy to have you. If you can't, obviously, I understand completely. All right, let's see. Slanked says, first of all, Slank, thank you very much for your super chat contribution. I really appreciate it. He writes, well, I don't agree with you on everything. Well, that's appropriate enough. Your commentary is insightful and educational and funny. Well, thanks, Mom. Thanks for all the entertainment and background noise at work. Keep up the great work. Yes, I really appreciate that. Thank you very much. TC asks, and TC, thank you for your super chat contribution. What was the caliber of the pistol used in this shooting? I actually don't know, but it doesn't really matter from a legal perspective. I mean, if you're wondering how this woman was shot twice in the chest and still remarkably functional in the sense that she was apparently fighting back with her cell phone and is alive today to testify in court, that's a great question. Handguns are remarkably ineffective, really, at their intended purpose, unless you hit something of vital importance. And it's easy not to do that. Normally, upper chest hits tend to hit things that are vitally important, but obviously in her case, not so much. So, but legally speaking, it doesn't matter whether he shot her with a 22 or 380 or 9 or 40 or 45. It's all deadly force and requires the same justification. So makes no difference. All right, so those are all the super chats. So at that point, I will see if I can, start up the second video now. Let's see if I got the right one. Yes, I can tell it's the right one because she's wearing a blanket. The witness, Lauren Kanarek, is now wearing a blanket over her shoulders. Let me fast forward past the quiet part. Okay, so the judge is standing up. When we join in, the judge is standing up because the jury is being brought back in. I guess he dismissed the jury for this most recent bar session with the defense. Maybe they decided to take their morning break at that time, which would be reasonable enough. And here we go, folks. Almost 3 hours in, and we have another hour of this. This video here clip is an hour. Only a portion of that is ongoing cross-exam of this witness, Lauren Kanarek, the primary victim in this case, and then the state has some redirect. And I think that wraps things up for this witness. So here we go.
All right, very good. Be seated. Everyone, we'll continue. The court did rule on the last objection. The objection was sustained. Ask another question, Mr. Belinkus.
Ms. Kanarek, when I showed you D803, I had you make a marking as to where you were standing when you got shot with a pen that really didn't
Yes.
show anything. I got a Sharpie, I'm gonna ask you.
Oh, we're back to this. Look, it
Make
could
the next
theoretically
where
matter
you
where
were
she was standing when
on,
she got shot. So show me how it would matter.
You can see that better, correct? Can you put on that diagram where Michael Barisone was standing?
Yes, but there was a chair that's no longer.
It's possible that this defendant did nothing morally wrong when he shot her,
Did someone move the chair
but
based on your recollection?
he needs to demonstrate that what he did was not legally wrong. He could be morally right and spend the rest of his life in prison.
The chair is actually still there,
Okay,
but it's
well,
not.
just put where
Okay, so
Michael Barisone was standing when he shot you, irrespective of this.
I do not see this chair here, because the bush is there.
Right.
So,
Folks, she could be testifying right now wearing an actual witch's outfit with a pointy hat.
somewhere it's gone.
It still doesn't
Is
justify
it okay if I
his
move
shooting of
this
her.
Just right there, because that would be more accurate now that this chair, if
Let me,
you have to put it up somewhere.
I don't want this to be confusing.
Okay, yeah, it is.
This one? They're both the same one, 303. Yeah.
803, I'm gonna give you a new copy, so
Okay,
there's not a lot of different check marks on it.
okay.
Okay,
The,
so
the
on
explicit evidence so far in this case is that she was striking him with her phone
just put
after she was
an
shot.
X
Every time this
where
lawyer
you
tries
were
to suggest
standing
that she was
when you got shot
shot
twice in the chest.
while beating the defendant with the phone, there's a sidebar. So I presume the defense attorney's trying to get
And
that
could
as
you
evidence in
put
front of the jury, but there is no actual evidence to support that
Small
claim.
MB
And therefore the judge is not allowing it.
depicting where Michael Barisone was standing.
As best as possible, sure. Can I just look at that?
Caliber,
line?
choice of caliber or choice of round all really have no relevance in a self-defense
I'll
case,
just
but
put
it's
what
talked
counsel
about
asked
all
you
the
to
time
Just
by
put
prosecutors.
a
You
small
never
NB.
have
NB.
the right kind of ammo.
I'm sorry.
If you had hollow point, you should have used ball because hollow point creates more grievous injuries. If you used ball,
All right,
you
but
should have used
before
hollow
she
point
goes-
because
before
ball
you go,
overpenetrates and could have harmed an
Just so
innocent
the
person.
record is clear,
It's
I want
always
the,
the wrong bullet.
witness
Don't
Ms.
worry about
Kanarek
that.
to mark today's date and put her initials so we know in the
I do
future
encourage people
who
to
marked the
make their
photograph, and
self-defense
there's no
tools be
question
as
about it.
boring as possible. Whatever
It's
your
the
local
31st, I
PD
believe.
carries, probably a good choice for you, assuming, of course, that would be lawful.
Oh, there's, just kidding. 20%.
I think it's the 31st.
Yes.
Yes, all right.
20%.
Yeah, I'm familiar with the Harold Fish case in Arizona. The prosecutor made a big deal about him using a 10 millimeter. 10 millimeter is not a
Fine,
common
thank you.
self-defense round. To my knowledge, no police department carries a 10
Now-
millimeter. And yes, I know the FBI
Do
did
you
for
notice
a
in
few
this
years after
diagram
the
that there's a
1986 massacre.
telephone on
but
that table.
They
right
gave it
where
up
the
too, didn't they?
shooting
They went to the
took place.
40 and then ultimately from the
I
40 to
didn't
the 9.
notice that in that picture, no.
Was Michael
Well,
Barisone?
hold on a second.
If you're carrying a 10 millimeter or a 44 Magnum or a 454 Casel or a 500 Smith & Wesson, some bizarre round for personal protection, I can assure you a prosecutor will make of that as much as they possibly can. Should it matter? No. It's deadly force, but a 380, a 22 long rifle is also deadly force. Legally, it should not matter. But, you know,
When you
prosecutors are
first
allowed to talk
came
about this
down
kind of
to
stuff
speak to
to
Michael
try to make you
Barisone,
look bad in front of a jury. Be
Did you notice
boring.
that he was holding the phone?
No, you're not.
At any point in time prior to the shooting, did you observe Michael Barisone holding his telephone?
No, you're not.
Now, and again, correct me if I'm wrong, he was standing where you've put an MB, correct?
Correct.
You were standing where you put this little star, correct?
Correct.
And it's your testimony that he fired 2 shots, one right after the other, correct?
Correct.
And then from that same position, a shot towards your boyfriend.
Correct.
All 3 within a matter of seconds, correct?
Correct.
And the whole time that the shooting took place, you were holding his phone, Rob's phone,
Yes.
and you were on the line with your civil lawyer, correct?
Yes, he was on the line, correct.
On August 4th, did you send Michael Barisone that you were going to send people that he didn't know to the farm to ride your horses?
I did.
And did you also tell him that you were going to be having an elderly person and an infant move into his house while you were away?
No, I did not say that. They were going to be moving in anywhere.
So all of this would be, let's assume that both of these things were actually said. These are just more steps to torture this defendant. Having, strangers, unknown people come in and ride horses without liability waivers, releases, would be a huge legal risk for this guy, for this defendant on his horse ranch. So she's threatening to do things that create genuine legal risk for him that could destroy his career, make him lose everything in a civil suit if somebody got injured riding those horses without having signed the appropriate releases. She's doing this intentionally to antagonize and threaten him in that context. But none of this justifies him shooting her in a legal sense.
That I recall.
Do you recall saying words to the effect One may be a child whom you already met, along with his grandma. When I decide for sure, I'll surely let you know. Did you send that text to me?
Yes.
Folks, lots of people get killed dead with 380s. So, I mean, you know, we mock it all we like, but appropriately placed, it's a killing round. That said, I only very rarely carried a 380. It would have to be unusual circumstances. Normal carry for me is a 9. These days, I've carried a 40, did it for years, carried a 45 for 20 years.
Now,
But these days
were
it's a
you
9.
aware of the fact that Ruth Cox had a gun?
I don't believe before the
Shooting?
I was not aware that she 100% had a gun, no. I thought she might have, but I didn't know for sure.
Do you recall telling the Morris County Prosecutor's Office?
Mr. Malinkas, before we do that, can I see you at the bench, please?
What's the judge really asking? I mean, it would be nice if you could pay like a $20 subscription fee and hear all these bench comments. He's probably asking them, where the heck are you going here? What difference does it make if somebody not even present for the shooting happens to own a gun? Yeah, when I was in my 20s, I carried just a full-size 5-inch 1911 and carried that gun for 20 years. That was also my competition gun for USPSA and IDPA, and put maybe 100,000 rounds through that gun over those years. I loved it. It's a great pointing gun. Still runs like a machine. It was not a cheap 1911. It was quite expensive 1911. But I just got to the point where I became more interested in having more BBs on board than an 8+1 round 1911 allowed for. The Staccato is a nice pistol. The ones I've seen, but the only ones I've seen have been rather large competition size guns. I don't know if they make a carry version of their gun, but it looked like a quite nice, double stack 1911. I know they're quite popular. I see a remarkable number of them in other people's hands. I don't have one myself. Yeah, 1911s are a funny gun, folks. Model. They're not like Glocks. You know, you buy one Glock 17 is largely identical to another Glock 17, but 1911s have a very high degree of variance in terms of reliability. You know, there's a big difference between a $600 1911 and a $3,000 1911.
All right, based on the court's ruling, Mr. Malinkas, you can rephrase your question.
Thank you. You just indicated, did you not, that you weren't sure if Ruth had a gun, correct?
I was not positive. Correct.
What, I'm sorry, are you talking about in August or at any point in time?
Any point in time?
All right, that's the question, just so you understand, all right? Any point in time he's asking,
Okay.
not specifically in August, just any point in time. Ask it that way, so now the witness knows what you're asking.
Johnny the Trailer Slayer, those Gold Cup stainless 38 Supers are beautiful guns. If I had one, I wouldn't get rid of it either. I wouldn't carry it, but they're really nice pieces of work.
Correct.
And that she travels with her guns like a crazy freak, correct?
And if I lived in a place that had a
Yeah.
like a 10-round mag
Yeah.
limit,
Yeah,
I would
yeah,
absolutely
Mr.
go back
Blankus,
to my
that's not what we-
1911.
That's not what we talked about.
Okay,
No, you're reading for, you can refresh your recollection, but not quote from that. That's not evidence. That's not substantive evidence. If you think you need to refresh your recollection, you can do that
This
by
is so
showing her the
basic. It's
document as
unbelievable
you've done
this lawyer
before.
keeps doing this. He
And
knows.
ask her if it refreshes
I mean,
her
he should have
recollection.
known already
But I think
before
she
ever
answered
stepping
the
into this
question. She
courtroom,
said
but
she
he's
knows
certainly
Ruth
been
has
told
a gun.
enough by
Now
the
ask a
judge.
follow-up question. You
You
don't have to
can't just
quote from the
read this stuff
transcript.
out loud.
you're aware of the fact that she always carries her guns with her, correct?
I don't think I'm aware that she always carries them, just that there's been times I know she's carried them, or.
Again, I'm gonna show you, when you look at page 26, line,
The judge really means it's not
19.
permissible as evidence. When he says this is not substantive evidence.
Recollection,
The lawyer
So sorry,
reading
which
stuff
page?
aloud,
20?
basically
26.
testifying to the jury
26.
is not permissible evidence. I do have a Smith & Wesson 1911 in 9mm, and that is a very nice 1911. And it was, I want to say it was
And 19.
$900, something like that, when I bought it a decade ago.
and ask if that refreshes your recollection as to whether or not you were aware that Ruth Cock always travels with a gun.
I'm sorry, can I just have 1 second to read the?
Yes, go ahead. Read it to yourself.
Thank you, sure.
Please.
Okay, and then can you just ask the question one more time after I've now read this? I'm so sorry. Just want to be clear.
Are you aware that Ruth always travels from where she lives to the farm with her guns?
No, I am not aware that she always travels.
See, this is just a poorly phrased
Did
question.
you tell
He's
the
asking a
prosecutor
question on
that she's
cross
not a person
that of course
who
the
had
defendant
driven
can,
their
the
overnight
witness can
on
answer no
farm?
to. When you phrase these things in absolutes, no one always carries a gun under every circumstance. How would you possibly know that?
1929.
Yep, I know, I'm reading it, I'm sorry. So yes, that is.
Does
the
this
last
person
part of it.
habitually, do they commonly, do they often?
So you were aware that she, based on your knowledge.
And even then, it's not a great question because the defendant can always claim they don't know.
Okay, now, let's go,
If they're hostile, if it's a friendly witness, they'll say, "Oh yeah, I know they habitually carry a gun."
immediately.
If they're hostile, they'll say, "Well, I don't
Before
really know that."
you walking down to talk to Michael Barisone on August 7th.
Oh, okay.
Number one, you were pissed, correct?
So
Yes.
I want to comment on this. Goober Thoreau notes that, quote, "It also sounds like the defense attorney has drawn conclusions for these text messages. I presume he means from these text messages that he doesn't know for sure are correct," close quote. So it's common to see among people who are not good attorneys that they get high on their own supply. They look at the evidence and they see a narrative that's favorable to their client, and that is all they're capable of seeing. And it can happen to prosecutions too. We saw this in the Curtis Reeves trial. The prosecution would look at that evidence and then would lay out a narrative in front of the jury and be blindsided when that narrative was exploded, reasonably enough, by the defense. Here we appear to have a defense lawyer who's looked at the evidence and has come up with a narrative, a view of this evidence that's favorable to their client, and they're incapable of seeing the other variations of that narrative that are not helpful to their client. They're unable to see what ought to be fairly obvious avenues of attack, weaknesses in their narrative. And a good attorney sees it all. A good attorney, you can take them and drop them on either side of the case, and they'll be competent. They'll work with what they have. It doesn't mean they'll win, but they'll be competent. They can make the arguments on both sides, because if you can't see the other side's arguments, how can you possibly be prepared to counter them? And the way this guy keeps getting stumped by objections, like he never considered this would be an objection. Listen, I get it. Sometimes you just try to get stuff in front of the jury, and maybe the other side will object or not, and if they don't, you got it in. It's objectionable though. You know that, and you know why it's objectionable. And so if you get objected to, well, all right, you gave it a shot, right? You got caught. It's fine. There's no real penalty for that. But this guy keeps getting blocked and appears to be stumped that this happened. It's a sign of not being a very good attorney. I'm sorry. It's really unfortunate. But that's the way it is. And there's a lot more of these guys out there than you might imagine. There's a reason most attorneys don't do trial work, because
Correct?
Mr. Belinkas, are you reading from a transcript?
I'm asking a question, sir.
Oh, why are you flipping the transcript? It looks like you're reading it. Don't do that. If you ask a question, ask it. A transcript is used to refresh recollection.
Did you come down stomping?
No,
Can you please look at page 28?
who
line
cares?
19,
Who cares if she was stomping?
and tell me if it refreshes your recollection with regards to whether or not you came down stomping to talk to Michael Barisone.
not exactly.
And
sure.
remember,
I
as
think
contemptible
especially
as this
somewhere
woman may
in
be,
between.
and it wouldn't be hard to sell me on that,
Yes,
she's not on trial.
Okay?
I did say the words, I came stomping.
Okay, now, when you first had a conversation with Barisone, did you describe him as a crazy person to the prosecutor?
Yes, probably.
Now, before the shooting, is it not a fact that you never saw the gun prior to it being fired?
Prior to, I
The gun
never,
being fired,
I never saw it
you
prior to.
never saw it prior to the gun being fired.
Yeah, folks. So those of you in the
I saw
comments
it just before it
asking
was fired.
uncivil law to
Well, that's
join in,
fine.
I'm more than happy to have him. But keep in mind, he's got his own
Okay.
channel to run.
Can
I
you
did
please
send
go to
him an
page
invite in the link,
32,
so I hope he can make it. But if he can't, I'm sure it's because he's busy doing his own thing.
Lines 5 through, or 4 through 6, and ask
Oh, wait, 35, so I'm sorry.
32,
32, lines 4 to 6.
4 to 6, and ask if that refreshes your recollection as to whether or not you actually saw the gun prior to it being fired.
And by the way, for those comparing this lawyer to Binger, you may think that Binger was
Yes, I
contemptible.
saw the
I don't
gun
think much of
prior
Prosecutor
to
Binger.
being fired.
Technically
Did you tell the
speaking,
prosecutor
he
that
was
you
a
did
good
not see the
attorney. He
gun
was good
prior
at his job from a
to it
technical
being
perspective.
fired?
Was his moral compass broken? I would suggest yes. Was he prosecuting Rittenhouse for political
Based
reasons
on
rather than
the
on legal
lines
merits?
you
I would
read,
suggest
8
yes.
through
But in terms of knowing which
8,
levers to
11?
pull,
4 through 6.
and frankly,
I refer
knowing
to.
how to manipulate that trial judge, Binger was good at what he did.
I'm sorry, this is just it's so all over the place. I'm sorry. I'm not really exactly
Just,
sure.
just read those lines to yourself,
Okay,
all right? And then Mr. Belinkas will ask if it refreshes your recollection
okay. Thank you.
about what you saw regarding the gun
Okay,
prior to the shooting.
okay. Thank you. So, yeah, no. Yeah,
Is it in fact you told the prosecutor that you did not see the gun prior to it being fired?
yes,
That's,
Judge, that's not what it says.
Well, you can clear it up on redirect. That's what it's for.
well, let's go to page,
I would point that out too, by the way, because you want to put a little marker in the juror's mind. So when you come back to it on redirect, they'll know what you're talking
did
about.
you ever see the weapon in his hand?
yes,
Can you please go to page 33, lines 10 and 11, and see if that refreshes your recollection as to whether or not you ever saw a weapon in his hand.
well, I'm sorry, lines 10 and 11?
Yes, page 33, lines 10 and 11.
Okay.
Judge, while the witness is reviewing that, can we come aside?
Sure.
Yeah. So the state wants to point out that, Your Honor, he's misleading the jury. He's misrepresenting this evidence. And the jury, when I come back to it on redirect 40 minutes from now, the jury's not going to remember what I'm talking about. This needs to stop now. It's not appropriate for him to misread the transcript and then require me to make up that ground in redirect 40 minutes from now. Yeah, I have not seen the prosecutor here work in this trial, except that I saw his opening statement, which was pleasantly concise. It was only about 20 minutes or so. So that's always appreciated. He seemed fine in opening. He looks like he's 12, but that's because I'm 57. And it's weird how the defense keeps referring to her like, and that's when you
Did
claim
tell
you were
the
shot, as if
prosecutor that you never
to imply
saw
she
a
wasn't shot?
weapon
I mean-
in his hand.
Yes,
How many shots did you tell the prosecutor he fired at you?
I honestly don't remember. Maybe I might have said 3, I might have said 5. It was-
Wasn't this gone over yesterday? I believe it was.
She testified on direct to 3.
The judge believes it was gone over yesterday.
Did you tell the prosecutor?
Hold on, Mr. Blank.
Jesus, wait for the judge is obviously looking to
Yeah, you
haul
showed
your
her
ass up.
D200 and G. And we had, you cross-examined her on whether it was 3, 4, or 5 shots.
And I'm asking her now if she told the prosecutor 5 shots.
No, Mr. Belinkus, it's been gone over already.
Now,
I guess that's the judge being biased again, right? For all the judge haters. I don't know anything about this judge except what I've seen in this courtroom, and he looks totally fine to me.
Later on, I can't get into that.
Well, you shouldn't characterize anything one way or the other. That's the first thing.
This is.
But
her character.
But this is not, this one was over yesterday. You went through this yesterday.
And I'm going over with her statement with the prosecutor's office.
I'll
Bobby
allow a
Sue, you
brief
keep
question on it,
commenting
but
that you're
do
going to
not
leave. How can we miss
get
you
into the
if you won't
same
go
ground
away?
we covered yesterday.
You don't need to tell us you're leaving.
Did you-
Just go.
Say, so it may have been more, but definitely 5.
Actually, after watching the
No,
testimony.
no. Hold on.
Before we go.
The question is just, are you asking if it refreshes her recollection
Yes.
now?
Yes.
Oh, should have asked that. The question is, in reading, and what's the page and line number, please? Because I don't think that was made clear to the witness.
Page 35, line 15.
Page
First
30,
two-
yeah.
First 2 words.
Just read that to yourself.
Okay.
And tell me, does it refresh your recollection about the number of shots that were fired?
The
Yes.
judge is doing defense counsel's job here
How many
because he
shots
can't
were
stand
fired?
the incoherence anymore.
3 shots were fired.
Now, you just mentioned, after going over the testimony, did you look at or see anyone's testimony on YouTube or?
I'm sorry you
my
find
own
it so
testimony.
uncomfortable
I
here, Bobby
gave it.
Sue. I can fix that for
Please.
you. Watch this. It's like a
I was
magic
showing
trick.
testimony.
There you go. Now you don't have to worry about it anymore.
Do you recall telling the police immediately after being shot, you disappeared?
Don't know what I said. to the
You
police.
just went over this already,
Oh.
Mr. Belinkus. Move on to a different area. This is becoming repetitious now.
Now, Ms. Kanarek, you have or had access.
Oh, by the way, folks,
to
I don't do
Michael
civil
Barisone's
work, but it's quite
personal
possible that Michael
office
Barisone would have had a
off of the
civil
club room,
cause of
correct?
action against these
No.
people for their
Hasn't.
efforts to destroy his reputation, destroy him psychologically, intentional infliction of emotional and stress. He might have had cause to
Did you
drag them
ever
into
go
civil
into
suit,
Michael
sue them for
Barisone's
damages and
office?
harm done to him.
And take personal items.
But
No.
the fact that he was being bullied and tortured
I'm gonna show
mentally
you-
and psychologically by these people does in no way raises a justification for him shooting them. We don't live in that world. Yeah, I'll just remind everybody, if you could hit that subscribe button, I'd really appreciate it. Thank you. Hit the
I'll
like,
show you what
thumbs
has
up,
been marked 2
hit the bell. Don't forget to hit the bell. So
2C-30.
maybe YouTube will notify you when we put content up. And most of our content these days is these live streams.
Ask you to read item 4844.
Thank you.
I don't know what the second chair is doing here in this trial. I mean, so far he may as well be one of those like stuffed Norm characters you see in a Cheers bar. It's just completely pointless. I shouldn't say pointless. Maybe he's doing something behind the scenes. I don't know. But if he's making a contribution, it's not being reflected in
boyfriend.
actual performance.
Yeah,
And your dad.
correct.
Yeah,
Does
don't
that
count on
refresh
getting
your
notified by
recollection
YouTube.
As to whether or
They
not
generally don't. Best actually to be on our
On
email
July
list, and
11th,
we also send out emails to folks on our list.
2019,
Easiest
You
way to do
have
that is to get our
obtained-
5 elements of self-defense webinar.
access
Infographic.
Michael's
You can get that at
office.
lawselfdefense.com/elements.
Yes.
And when you
Yes,
download
yes.
that, you
and-
can provide
and
us
did
with
you
your
take
email.
any
and then you'll
damaging materials
More definite
from his
notification directly from us,
personal
as opposed to
office?
relying on
No, I
YouTube.
did not.
Did you say you took damaging?
YouTube
materials
doesn't like me,
in
folks.
this
I don't know why,
communication
but
with your
they'll
boyfriend and
routinely
father?
No, I did not. say that.
demonetize an hour-long show because I used 15 seconds of
Did you
someone's
say,
video
"I'm
clip,
pretty good at locating
and
damaging
that someone,
material.
or
Now
even
that
someone
I
who
have
doesn't
access
actually have a
to
copyright
Michael's
claim in the clip,
office, I can
like
write
Fox Sports
contracts,
News.
get his
How many Fox
signature.
Sports News clips do you think
Whatever
I
I
use?
need to do.
They'll just demonetize the whole hour.
Judge, I'm going to ask that be stricken. It's not responsive to the question. It's not impeachment.
I'm going to rewind it because that may have been.
Did you say, I'm pretty good at locating damaging material? Now that I have access to Michael's office, I can write contracts, get his signature, whatever I need to do.
Yes,
Judge, I'm going to ask that be stricken. It's not.
So she's a witch, right? I mean, can we agree? She was going to write presumably false contracts, maybe get a signature stamp. I'm not sure what she means by signature, but clearly she's intent on some kind of action that would be harmful to this defendant having access to his office. That's horrible. It's still not a justification for shooting her.
It's not responsive to the question. It's not impeachment.
Folks, I'll drop it in the comments here, but you can also always get a, where's my soft cover? Well, this is the hardcover of our book, The Law of Self-Defense. You can get a free copy of the soft cover at lawofselfdefense.com/free book. I'll drop that link in the comments here. We do ask that you cover the cost of shipping the book to you. USPS charges us money for that. We have warehouse people we have to pay, but we'll eat the cost of the book. Or you can order the book from Amazon and pay for the book and the shipping. It's up to you. But if you'd like to get the book for just the shipping, you can get that at lawofselfdefense.com/free book. Easy to remember.
I'd ask
Free
another
book.
question, Mr. Belenkus. Objection sustained.
If you'd like the hardcover, they're not free, but you can get those at lawofselfdefense.com/gethard. They are beautiful books. They're really nicely bound. They look great on the bookshelf.
Did there
Good
come a
gifts.
time
Father's
when,
Day is coming up.
You became aware that Michael Barisone was going to install web cameras in and around the stable area?
So was there a time that I became aware?
I'm not assuming Barisone shot her. She was shot. She says it was Barisone. Barisone does not say he did not shoot her.
That there was
His defense attorney
discussion
did not say my client did not shoot that woman in opening
install
statement.
Cameras around the.
I'm not assuming anything. I'm looking at the evidence.
After you found that out,
His own defense attorney spoke to insanity defense and self-defense in his opening statement. That's not a my client didn't do it defense.
and I'm
That's a my
referring to
client
August
did it
2nd,
defense.
2019.
But he should be excused on grounds of insanity or justified on grounds of self-defense.
Did you intend to look for them and disable them?
Maybe.
And could you tell the ladies and gentlemen
If you
of the
can
jury
speculate a
why you
defense,
would
but the
want
defense counsel's not
to
making it, it's
disable
not relevant to the
Michael
case, folks.
Barisone's cameras in the stable
The jury's
area?
never going to hear your speculative theory of
I
this case.
Don't really have a reason, but I don't know the context either.
I'm going to show you Defense Exhibit 100C. C16, sorry.
Yeah, to the extent they're going for a diminished capacity or insanity or imperfect self-defense based on objective unreasonableness, they may want their client to look as if he has diminished
sure you
capacity or is
100%
crazy, and
did.
therefore you leave him
16.
scruffy looking. The opposite of the Edgecombe case, right? In the Edgecombe trial, they cleaned up the defendant, which is what normally happens. They cut his hair, they put him in a suit. Here, they're going for a different take, which is that our client's not super competent,
019.
but it's quite the contrary, that he's incompetent.
They're all. That's a zero, right?
Yep.
Okay, cut off.
Migraine writes his 9 and 12-year-old are watching this, and they feel they could do a better job. Perhaps.
All the ones that say 019?
No.
They're all listed as that.
Okay, so
It's remarkable to me how many of you would like to live in a world where you can shoot bullies. And on an emotional level, I get it. But we don't live in that world, folks.
Okay, so I'll make sure to record as well.
right here. Okay.
Where there's like
Yep.
marks.
And you don't have to all caps me. I'm not yelling at you. If he wasn't competent, why would he be up there at trial? Because you don't have to be competent to be a practicing attorney. That's why.
I'm sorry, was your question, what was your question again about this?
Did you plan, after finding out
Judge,
that
that was not what the question
Yeah.
was.
Jesus. I mean, you have to hope that the defense counsel is just inept, because if this is deliberately orchestrated, it's oh my God, it's misconduct. He better hope the judge does not decide he's deliberately acting this stupid. The defense did mention self-defense in passing in opening. They had about a 45-minute opening statement. I think fewer than 5 minutes of it talked about any notion of self-defense. The large majority focused on issues around an insanity defense. But they don't have to have mentioned self-defense in opening to raise it at trial. It's possible over the course of the trial that facts or testimony evidence develops in such a way that there is a factual, an evidentiary foundation to justify a self-defense charge. That can happen. And then you get the self-defense instruction at the end, even if you didn't argue it at the beginning. But he did mention it in passing, self-defense, in opening statement, the defense counsel.
All right, move on, Mr. Belinkus.
Judge, I have no further questions.
That's it.
Fine, we'll do redirect.
That's it for
Thank you,
cross-examination. That was really
Ms.
not
Kanarek,
good, folks.
you still have that transcript in front of you?
Not
No, you
good.
just took everything.
I saw no substantive evidence of self-defense in that cross.
For
Not
the
even
record, this is
really
defendant's
effectively phrased
200G.
questions in support of self-defense. You'd expect her to lie
Maybe
about
you
it,
showed
right?
her the
She's a
witness.
woman who got shot. She's not going to say, yeah, I
You
attacked
asked
him. That's
us
why he
series of
shot me.
Questions about, did you see the gun before you got shot, or did you not see the gun before you got shot? And I believe Mr. Belinkus had taken a line on page 33, line 10, if you could just turn to that.
Sure. Yes,
He asked you the question on line 10, if you were asked the question, so you never saw a weapon in his hand, and your answer was no?
Yep.
Is there context for that if we go
I
back?
believe he's testifying. I have no problem with him asking.
Oh, my
her.
God.
Well, just.
The
yeah,
balls
Mr.
on this
Shellhorn,
guy.
Just,
I'm just directing her to
fine.
the page.
It's a, I understand, it's
I
a,
would ask that he not read it, Judge.
right, you can ask her, what did she say on so-and-so page and line so-and-so, as Mr. Belinkus does, to see if that refreshes her recollection about what she said on a later page or a page before. That's fine.
So that was on page 33, Ms. Kanarek?
yes.
I'm going to ask you to direct your attention back to page 30,
Sure.
which is 3 pages before.
Yes.
And I'm going to ask you to direct your attention to lines 8, 9.
If this
10,
little
and
woman
11.
attacked Michael
Do you see those
Barisone
lines?
by whacking him with her
On
cell
lines
phone,
8 to 10,
that's not a
did
deadly
Detective
force
Rogers
attack
ask
that
you a
would
question?
justify him shooting
Yeah.
her.
What
So
was the
even if that
question
were
he asked?
true, it's not sufficient to
Sure.
justify the
Judge,
shooting.
No, a question's fine. It's not, the question is not hearsay, it's a question. It's not,
Yes,
it's not a statement. Go ahead.
So he asked me.
What
so
did he ask you?
He asked me, so when you were coming out and he was behind the bush and you couldn't see him, I said,
Go ahead, and what was your answer?
I said, yeah.
What did he ask you on lines 12 and 13?
He said, so you were walking toward him?
What was your answer?
And I said, yes, I said toward him.
So does that put in reference the point in time that we're talking about in the
Objection, he's
statement?
testifying.
No, I'll allow it.
Suddenly, this
if I
defense
direct
lawyer knows
you
what a lawyer
ahead
testifying is like.
To page 31.
Yes.
Are you still talking about the same context and about the same part of the incident?
Yes. Let me see.
No, the
In
judge
other
is
words,
not
the
going to
subject
declare a
didn't
mistrial
change
because the
on page
lawyers
No,
didn't
30.
have
no,
to.
the subject didn't change.
Is there an objection?
No, I'm trying to figure out the page. in the
All right, what's the page number?
Just in general, I want to establish, Judge, that page 32, the subject didn't change. The point in time of the shooting was still where the defendant had pulled in, gotten out, and was standing by the bush.
Yes.
Now on page 32, were you asked a question by Detective Rogers on lines 4 and 5?
Yes.
What was the question?
Did you see, at that point, did you even see a gun or anything? You just,
And what was your answer on the next line?
no.
What was your answer on lines 8 through 11, if you could read that?
Sure. I wrote, I didn't even know he had the gun
Again, Judge.
until,
she's reading
Oh,
the-
it's a prior consistent statement. All right, you attacked the credibility. The state has a right to introduce prior consistent statements of the witness under the rules. 607. Go ahead, Mr. Shelmore.
Ms. Kanarek, if you could just continue reading lines 8 to 11. Out loud, please.
I'll start over. I didn't even know he had the gun until he said something and I responded. And like in the middle of my sentence, I was cut off because I just see him pull out the gun.
Now she's
Now,
going
if
to
you
cry.
could turn back to page 6 of that transcript,
Yes.
and I'm going to direct your attention to line 14 to 16. Do you see where I'm referring to?
Yes. Page 6, 14, 16.
And can you read those lines? Starting on line 14 with the word "and."
Page 6, this is?
Page 6.
Well, having someone
Line 14,
specialized in
if you
self-defense
can
law
start
is
with
always
the word
helpful
and.
when you're arguing a self-defense case.
And
Um,
the
but
minute, like, that
they need a
word
lawyer
started
who
to
just
come
has
out
a
of my
higher level
mouth,
of competence than what
I
this
just
defense
see
counsel is
a
bringing to
gun
the
come out of
table.
his pocket, and like I was in that second, very second, like in shock.
Thank you. So does that clarify whether you saw the gun before Michael Barisone shot you with the gun?
Yes.
Now, continuing on that same paragraph, I think you were asked a series of questions by Mr. Belinkis this morning and perhaps yesterday about what happened after you got shot. Do you remember those questions?
Some of them.
Do you
So we've got
remember
about
being
20
asked
more
some
minutes of
those
this,
questions
folks.
by the detectives when they questioned you in September of 2019?
Some of them.
And again, on page 6 of that statement, specifically on lines 20 to 22,
Mhm.
what did you tell them in September of 2019 about what you remembered after you got shot?
Starting line 20 of page 6.
Yes.
Should I start with the word "and" or
Yes.
"and"? This is the point where it gets like
It's so funny how
shady.
people
Judge,
presume
she
my
left
life
out
experience.
3 words.
Mom is lazy, writes.
Just read the entire,
I presume she means my last
Line,
name.
if you
Branka,
would,
you have
ma'am.
clearly not had a crazy woman attack you
I took
physically.
the
Mom
whole-
is
until the
lazy.
sentence
You would be
before the end.
mistaken. I had a
You
crazy
start with
woman
and.
attack me physically just
Right.
last year
Start with "and."
in a bar
And
where I was having dinner. I even
this
have it
is
on
the point
video.
Where it gets.
Judge, she's leaving out 3 words.
Judge, do you want a copy?
yeah,
You can follow
I don't have a transcript, so I'm lost here.
We're right here, Judge, starting with the word "and."
Why did the
Starting
crazy
with
woman
and.
attack me? Because she was
All right,
crazy.
Go ahead, read.
And this is the point where it gets like,
Where is she leaving it out?
I've shared the video
Mine
before.
says- mine's
I'll share it
quoted,
again sometime.
"And as I ran at this."
No, it was not my
you're
ex-wife.
looking at the wrong "and."
Last year was
It's
not
the
my
next
ex-wife. I
sentence
haven't seen my
begins
ex-wife in quite some
"and"
time.
with a capital A. That's what she's,
No, I didn't shoot her.
that's the same line. It's right next to it.
Even though she
line
punched
20.
me.
Page
The
6.
end that you're referring to is the line before.
She was about the size of this witness. I wasn't too worried about her punch.
So not leaving it out, she was directed to read that line. Go ahead, read where it begins, ma'am, with a capital "and."
Yes, Your Honor. And this is the
They
point
kicked her out.
where it gets like,
The management of
shady,
the
'cause I
the
don't know
bar
where the
slash
hell I
restaurant threw her out. They were very apologetic. They were quite nice.
That to the detectives the day that they interviewed you. in
I don't know if
September
they're
of
planning on putting
2019.
the defendant on the witness stand. I don't know.
What do you mean by the word shady?
You know, presumably
I
he
mean,
doesn't
like,
have a criminal background, so you have that
confusing
going
a
for
little
you. But you know, that's not the only risk of putting a defendant on the stand.
I also wanted
you
to
never know
ask
what's
you,
going to come out of their mouth.
some questions. I don't have any other questions.
Especially
about
if
the
you think they're
transfer for
crazy.
Ms. Kanarek, so you can close that up. Judge, if I could have permission to display S210.
The steak was excellent. Yeah, that's why.
Corresponding
I mean, to be honest,
D803.
I turned on my
Witness was
phone
shown.
because she was giving off a crazy
I think
vibe.
of
I
that.
probably should just have left.
It's not
But they had
corresponding,
just
but
delivered my
S210
steak,
in
just
there.
delivered it. I was hoping it would not go
Yes.
sideways, but I was recording just in
S210
case
will
it
be
did.
shown on the screens,
And it did.
please.
So
Ms. Kanarek,
you'd have to
what's
ask her why she punched me. I
S210 a
think it was
picture of?
because I was not giving her the
the
attention she was
porch,
seeking.
Table and chairs.
And what is in the top right of that picture?
A bush.
A bush.
Can you just, I think the jury probably knows this, but if you just orient them to where that bush is located with respect to the back door.
That bush,
It was a
is in
ribeye steak
between-
I was eating.
that little, I guess, mini roof thing and where the tables are, between there.
It was
and
pretty good.
where the
I was in
actual
Durango.
porch is, which leads to the
Durango,
front door.
Colorado, on a
And
motorcycle
it's
trip.
Only, a couple feet away, maybe 10 at most.
When you described coming out of the house, do you see on S210 the approximate area where you saw the defendant standing?
Yeah,
Medium rare.
Can you describe that for the jury?
yes.
You ask for a rare steak in Colorado, and they just throw a piece of raw meat on your plate.
So he was standing like sort of in the bush and also at the same time on the other side of the chair, which is not the chair that's in front of the white structure.
Judge,
Not-
I have no reference point. Can we have a point to where she's talking about? She's pointing to her screen.
I don't know if you can try that, ma'am. I'm not sure.
if that'll work.
It may not have been charged up and it's not effective even when it's fully charged. So, but you can try, see if it
Okay,
works. Just
doesn't work.
More
don't shine
judges
it in
criticizing
anyone's
the
eyes.
courtroom technology.
Okay, so where the defendant was standing?
Yes.
Well,
The approximate area where he was standing. Judge, would it be all right if I go over and
This
point to where
witness,
that-
I believe she was
cursor is-
41 at the time of
Yeah,
these
well,
events a
as
couple
long
years
as,
ago.
can the jurors see that, especially in the gallery? Can everyone see it? Yes. All right, they see where it is. No need to point. It's a little bit faint, but it shows up on the screen and it's where the chair is pulled into the table, the light, this is for the record, the light was shined to the left of that, between the chair and the small white structure with a roof. All right, next question.
You were asked a question about a phone on the table. Do you see a phone on the table in this picture?
Now I do, yes.
Are you aware if you or your boyfriend Robert ever had a white Google phone?
Never.
Did you see that phone there on the day that you got shot?
Nope.
Judge, I think we can stipulate that that was Mr. Barisone's phone.
Hold on. 200C for you?
200C. 47, 200C 47. I can show them mine. I don't have, this is.
I have no objection. I'm gonna go with that.
Judge, may I approach?
Yes.
Ms. Kanarek, I'm showing you what's been marked as 200C 47 for the record. Directing your attention to line 512.
Yes,
Do you remember being asked about what that text message said?
I do not. Oh, yeah, yes, I do.
You remember when Mr. Bolinkis asked you that
Yes,
question?
yes, yes.
I'm going to ask if you could go up to line 505
Sure.
and just read to yourself what that text message says.
Sure. Okay.
Now, I think you were asked the question on cross-examination whether you learned that Michael Barisone was deathly afraid of your father.
Yeah.
And you sent that text message to your father?
I sent it, yes, I did.
After reading the context of the text messages before it, what was the basis for you saying that Michael Barisone was deathly afraid of your father?
The basis for me saying it was that Michael himself said it, or indicated that no one there should hurt me because they shouldn't hurt me because I have a protective father, basically, is what the gist of it is.
So do you mean people at the barn?
Objection as to what she
Right.
means.
Yeah, don't lead her, just ask her what she meant by that, that's all.
Just to clarify, when you say people, in general, are you talking about a person or a group of people?
A group of people.
And what was the group of people in general? Was that, you don't have to use specific names, just who in general are you referring to?
Barn staff and one of their parents,
And what was the barn staff and the parents talking about?
coming to beat me up and punch me in the face and do me bodily harm.
And what did Michael Barisone respond to that after they said to come hurt you and do you bodily harm?
He said, no, no, no. Nope, not with the father like that. That's the wrong way to go about this.
And is it then 2 text messages later that you advised your father that Michael was deathly afraid of him?
Yes.
The last few questions I have for you, I'm not going to ask you about every Facebook post that you ever posted,
Okay.
but I do just want to clarify a few with you, if that's all right.
Sure.
Specifically, you were at Judge, the Facebook records are 402, so I'm just going to refer to the page numbers. I apologize, I didn't write down all of the exhibit numbers that the defense attorney used.
Yeah, this woman probably wrote tens of
So
thousands
this
of
was
words on
S402.
social media with malicious intent towards this defendant, and she probably can't remember everything she wrote. But her attitude on the witness stand is evidently that, hey, I wrote all that stuff on social media. The purpose of social media is shit talking other people. I was shit talking Michael Barisone. Yeah, I did all that. Still doesn't justify Barisone shooting her.
So Ms. Kanarek, we'll start with S402, page 968.
Sure.
I think you were asked about that post that you had on August 4th, 2019.
Yes.
And Mr. Bolinkis had asked you questions about certain sentences or certain lines in this specific post.
Yes.
Did he read this entire post in its entirety?
He did not.
Did he leave out a part where you said, I also feel that saying certain things to a public audience in some way helps keep me safe.
Yes, I did say that.
Did you say at the end of that post, there's only so much I'm willing to take from any person, anytime, before I unleash every legal resource and recourse that I have?
Yes,
On S402, page 814, I think you were asked a question about this post yesterday on July 27th, 2019.
mhm,
Do you remember being asked about, I think you had said something in that post to the effect of, "This is me, look out, because here I come"?
yep.
What did you remember that post to be in reference to?
It was an exact quote to The Greatest Showman. And I was basically just quoting that, meaning I, march the beat of my own drum kind of thing. And let's have a night of music kind of thing.
And what's, just in case anyone doesn't know, what's The Greatest Showman?
It's a movie that has songs in it, and I was quoting one of the songs from the soundtrack of that movie.
And did you put the lyrics to that song in quotation marks?
I did.
Did you finish it with TGSM?
Yep, The Greatest Showman.
What did you say after TGSM?
Let's have a night of music. Question mark.
The post before that, which was approximately 20 minutes before,
Mhm.
in general, what is that a reference to?
FN lawyer, this is almost done. I'll answer your CLE question for me when this wraps up.
Another song,
Who's that song by?
Meatloaf.
Is the post after The Greatest Showman post about another 20 minutes later or a half hour later?
Yes.
And what is that post in reference to?
Another song and movie, actually. A song and a movie.
And then the last post I'll ask you about is in S402, page 970. Do you remember being asked about a post you made on August 4th, 2019?
Yes.
This is a post where Mr. Belinkis asked you a series of questions about your gun
Yep.
and how many bullets it had,
Mhm.
and yes or no.
Oh, yes.
And I think he finished up at the end here by pointing out that you had something about if something turns violent, you would let someone punch you in the face twice.
Yes.
Did he leave a line out in the middle of that paragraph or that post?
Yes, he did.
What was the words that he left out when he read that post?
The words were, also, luckily, I am not a violent person.
Did he
I
die?
hate confrontations, which seem
Oh
they
my
could
gosh.
turn violent.
Did he also leave out this line starting with "unfortunately" after you talked about your two guns?
Yes.
What does that line say?
It says, unfortunately, or luckily, they are both in NC,
What is NC?
North Carolina.
Thank you. Judge, I don't have any further questions on redirect.
All right.
I have one, Judge.
Huh?
One question.
Recross?
With regards to D 200C-47, where you discussed staff members punching you in the face,
Mhm.
isn't the fact, and this is the day before the shooting, that you said you heard Michael say, no, 3 exclamation points, no, 4 exclamation points, no, 4 exclamation points. Did you write that with regards to what my client said regarding any violence towards you?
Yes.
Nothing further.
All right. Thank you, ma'am. You may step down. Please don't discuss the case with anyone.
All right, so that's
Very
it
good, thank
for
you.
Lauren Kanarek. And that was completely unproductive for the defense, except to show her as a horrible witch, which she made no effort to conceal. May go to some kind of diminished capacity, imperfect defense, imperfect self-defense argument. I saw nothing here that gets them any traction on self-defense. And of course, anything on insanity defense will really have to wait until we get the psychiatrist or the psychologist on. Yeah, I'm glad we counted out all those exclamation points. So for those who would like to see my little cell phone video from when I got punched by an old lady in a Durango bar a year or so ago, almost exactly a year ago, I'm going to share that video. It's very short. It's only 19 seconds. You can't see the woman involved. I was not angling the camera in that way. I had just started the recording just in case things went bad. But I believe you can hear the dialogue that's happening. So before I get to that, I want to answer a question posed by FN Lawyer about CLE. Do I do online CLE? CLE is continuing legal education. It's where lawyers go to get ongoing education, continuing education in the law. Most jurisdictions, I believe it's most, close to all, require practicing lawyers to get a certain number of hours of CLE every year. I'm accredited to teach CLE in some 35 or 40 states. I've taught in all those states at least once, often more than once. We've never been denied CLE accreditation anywhere we've applied. So I've done a great deal of CLE. And again, that's where other lawyers, judges, prosecutors, defense attorneys, that's where they come to learn self-defense law. So I like doing that kind of work. Unfortunately, the procedures for doing it in an online format with the attending lawyers getting CLE credits for it is highly varied from state to state and very obtrusive. So they do things like some jurisdictions make you drop in little secret numbers that the lawyer has to note while he's working his way through the online CLE, note it in a book, basically to prove that he was actually watching, that he just didn't turn it on and go play golf. Or various other mechanisms, and they're all different. And so we've never done online CLE because they make it too complicated. It's not worth the effort, honestly. So no, I've never done online CLE. In-person CLE many times in many states. Let me take a look at the Law Self-Defense member dashboard here. David mentions he watched My Cousin Vinny just 2 days ago. Yeah, I watch it probably once a year, once every couple of years. It's always good. I really enjoy that show. That movie. Let's see. Dale says, thank you, Andrew, for all your hours of studying and making the principles of self-defense make sense to the average person. I'm grateful for your expertise. Well, that's very kind of you to say. He also asked, will you be instructing at the Guardian Nation Conference again this year? Yes. I will be at the Guardian Nation Conference. I believe that's in September in Oklahoma City. Pretty good event, folks. I encourage you to check that out. Guardian Nation, it's one of these diverse, it's like Tom Givens and Lynn Givens' tactical conference where I just spoke at last week. It's a 2 or 3 day event where they bring together various forms of self-defense instruction, guns, knives, bare hands, trauma, medical care. If you're shot and you have a individual first aid kit, how to plug the holes, so you stay alive long enough for the professionals to get you. And they, on occasion, invite me to speak there. So I spoke at the Guardian Conference last year, and I'll be speaking there again this year in September. That's in Oklahoma City. And the tactical conference I just spoke at for 2022 a week ago, and they've invited me back to speak there again next year. I will caution that the tactical conference in particular sells out every single year, usually long before the date. I think it's scheduled for the last weekend in March for 2023. If that's of interest, and it ought to be, the instructors they bring together are really, I'm not talking about myself, the other instructors are really world class. It's an unbelievable opportunity. That one's in Dallas. So I would encourage you to Google Tactical Conference and Guardian Conference. And if you're interested in being more effective at self-defense, both tactically and legally, you may consider that. I don't get anything in particular for promoting those events. I just think they're good events. I only do like 3 or 4 events a year, folks, and those are 2 of them. So let's see. What else do we have? The defendant looks very disappointed in his attorney. That's from Dale again. Yeah, well, he probably ought to be. Yep, not so great. All right, so let me look at the super chats. What do we have here? Jeremy asks, thank you, Jeremy, for your super chat contribution. Asks, does ammo selection have any bearing on how a case might turn out? I talked about that earlier, actually. It really shouldn't from a strictly legal black and white letter of the law perspective. Every round is deadly force, regardless of the caliber or the nature of the round. Hollow points are not more deadly than ball's not more deadly than hollow points. I mean, from a legal perspective, I'm not talking from a terminal ballistics perspective. The way the law works at it, they're all deadly force, and there's not really a continuum of deadly force. All deadly force is basically treated the same as any other deadly force. That said, prosecutors will talk about anything they can get a hold of in an effort to make you look bad in front of a jury. And you never have the right kind of ammo. Whatever ammo you used, the prosecutor will argue to the jury it was the wrong kind. If it was hollow point, you should have used ball. If it was ball, a reasonable person would have used hollow point. The real question is not whether or not they can use this against you in court. They can use anything against you in court. If by used against you in court, we mean, can they talk about it in front of the jury in an effort to make you look bad? The question is, how damaging is that likely to be? How aberrant is it really? Is it so aberrant it makes you look unreasonable? For example, if you have hollow point bullets, and if you ever saw the old movie Jaws 2, there's a scene in that movie where the local sheriff is fighting a shark, preparing to fight a shark, and he's loading up his hollow point revolver ammo by putting, I don't know what it is, I forget now, a drop of cyanide or something in it, and then a little bit of wax, cyanide loaded bullets, I guess, I don't know. But if you were to do something crazy like that, yeah, sure, that would make you look unreasonable to a jury. The best thing to do is just be as boring as possible. Use whatever kind of ammo your local law enforcement uses, assuming that's legal for you to do. And that's the best you can get. Incendiary AP would also be, a shockingly unusual self-defense choice. Alfredo asks, it's a joke, I guess. Your Honor, the fact that she was shot twice in the chest and did not die is irrefutable proof that she is a heartless bee. Maybe, but I would not expect counsel to make that argument in front of the judge. Let's see. All right. Yeah, Eric, Marissa Tomei is hot, indeed. All right, so let me pull up that video. You can't really see anything in it except the way I'm holding the camera. It's just in case things go really sideways. I wanted the recording running already. They didn't go really sideways. Basically, the old lady gets thrown out of the bar/restaurant, and I get punched in the back by her as she's on her way out. By the way, she also had given there was a guitar player in the bar with a tip jar. And when she came in, she put money into his tip jar. And before she left, she took the money back out. She took her tip back, which the guitar player took in good humor, I have to say. And then she stomped out before the popo showed up because management was definitely throwing out. The video is only 19 seconds long. I actually don't even remember what's said on it. But don't have your expectations too high. But let me see if I can pull that up. Let's see. I believe I have it here. So what you'll see in the video is just the back of the bar. It's just an old Western type bar. By the way, this is in the Strater, Strater hotel in Durango, Colorado. It's an old West hotel with a bar restaurant in the basement. That hotel actually has what they call the Louis L'Amour room. If you know Louis L'Amour, he was an old, very voluminous writer of Western novels. I grew up reading them as a kid. They're still good reading, folks. They still hold up. I recommend it. Louis L'Amour. Many of his books were written while he was living in that hotel room for lengthy periods of time in Durango, Colorado. There's a little plaque there by the door. In fact, maybe I have a picture of the plaque. I wonder if I took a picture of that. Perhaps I did. Let me see here if I can pull that up. There's the Strater. There's the I guess I didn't. Oh, you know what? I might have taken the photo on the way home as opposed to the way there. I do have the photo. How about that? I'll see if I can pull that up. pause that, open this. Whoops. And here it is. All right, so let me pull that up just for fun and giggles. There we go. There's me wearing my, you can't really see it, but my law self-defense ball cap. And there's the plaque outside the Louis L'Amour room. It's room 222 in the Strader Hotel. This was back in May of last year when I took a ride through Colorado and Utah and various other places. Yes, contrarian, I'll check out Blood Meridian for my next motorcycle trip. I'll get that on audio and listen to it on the ride. So that was great fun. All right, so let me see if I can now pull up this video of my encounter with the crazy old lady in the restaurant bar of the Strader Hotel, so I'm at, normally when I'm sitting at a bar, I'm traveling by myself. I'm working. I'm on my laptop. So I'm plugging away on my laptop, and she tried to strike up conversation. So I was polite, of course, but I'm not really interested in, and she was obviously drunk. I'm not really interested in striking up conversations with drunk old ladies in bars. So I was polite, but focused on my work, and she did not like that one bit. She became pushy, touchy, shoving. The management behind the bar noticed this. They asked me if there was a problem. I said it appeared there was. They were preparing to throw her out. And that's when she decided, before the police showed up, she'd grab her coat, grab her tip back from the guitar player's tip jar. And then on our way out the door, she threw me a left hook in the back, which was fine. And then she left, and I, of course, never saw her again. Nothing ever came of it. If the police ever showed up, I never saw them. I was done with dinner at that point. But here we go. Let me see if I can just share that screen. There it is. There's the bar restaurant in the Strader Hotel. Again, it's only 19 seconds, and this is basically it moves a little bit, but basically all you see is the back of the bar. So we'll have to see if the audio comes through, because the only thing really on this would be the audio. So there we go. All right. So that's the guitar player in the background playing his music. That's the guy who gets his tip taken back. This might have been false advertising. Yeah, false advertising. Sorry, folks. That's not the right video clip. Let me see if I have it here. Darn it. I've shared it before, so I definitely have it someplace. Well, I apologize, folks. I'll have to look it up. I don't know where it is now. Very, very disappointing. Was it on the way back home? Yep. All right. Well, I'll have to do it on a future show, guys. Sorry about that. Hey, and my apologies. I'll make it up to you, I promise. I'll find out where it is. All right, folks. In the meantime, I think that's just about all I have for now. The next witness who may be interesting in this case is this woman's boyfriend, Robert something with a G. I forget his name. I believe, in some respects, his testimony contradicts, I've heard, this woman's testimony. He was shot at. He was not struck. He's the second victim, the second attempted murder charge here. I've heard that his testimony is humorous, at least, so we'll get something out of that. Maybe I'll cover that this afternoon. I believe he began his testimony yesterday, continued it today. We'll have to see. I'll dig it up, but you should expect there'll be a second show from me this afternoon. I'm going to take a break, grab something for lunch, break my intermittent fasting fast, and hopefully I'll see a bunch of you again later this afternoon. Thanks again. many thanks for getting me past 30,000 subscribers. I can't tell you how much I appreciate it. Don't forget our free webinar coming up, our Hard to Convict webinar, 100% free. We have a series of 5 of these over the course of the month of April. They're free. We don't cost a penny. We'll be busting the most common myths of self-defense law that could put you in prison if you believe these things to be true. They're not true. We don't charge a penny, but there's only 100 seats for each webinar. That's 500 webinars, 500 seats. And when I checked last night, we had about 200 of those seats gone already. I've only been talking about this for 2 days. So if you're interested in attending one of these 100% free webinars, I would encourage you to go to lawofselfdefense.com/hard-to-convict and grab your seat before they're all gone. In the meantime, remember, if you carry a gun so you're hard to kill, that's why I carry a gun, have every day of my adult life. So I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. All right, folks, until probably later today, this afternoon, my time, Colorado time, I'll sign off. I remain Attorney Andrew Branker for Law of Self-Defense. See you then.